Nau mai whakatau mai koutou katoa ki te kōmiti motuhake kia ōrite te utu mahi mā ngā wahine. Ka tika me mihi atu rā, kia tiatia wa whānui, kia toa rangatira, I tahu I te ahi ki te whanganui ātara, pai mārire kia tātou katoa. Ngā mate o te tau o te marama o te rā, haere, haere, haere atu rā. Tatu atu rā kia tātou e huitahi mai nei, nau mai, haere mai, rarau mai. Talofa lava, malo e lalei, bula vanaka, vanaka, Vakalevu, Nisambula, taloha ni hao, namaste, kia ora nā whakalofa lahi atu, and warm greetings to you all today. The government has changed the Equal Pay Amendment Act 2025 without public consultation, stopping some claims already in progress. It says the old system lacked strong evidence and was too broad. We want to test that. This committee is made up of former members of Parliament from across the political spectrum. We have come together to ensure voices are heard. We're here to do what the government did not. Your public submissions contribute to a democratic dialogue which enables open and transparent scrutiny. It is our collective belief that democracy is strengthened by such a process, and by hearing directly from those affected, alongside the wider public, we aim to consider the regulatory, economic and social considerations to inform the debate on pay equity that is informed, fair, evidence-based and without discrimination, and that those who are most affected should be able to have a say. On that note, as this is a People's Select Committee, the first of its kind I might add, we would like to stress that we operate under the ordinary laws and jurisdiction of the country, and no special privileges are accorded to ourselves or submitters. In that vein, we ask that comments which may be defamatory of any individual be refrained from, and we will alert submitters to comments that stray in this regard. The committee is supported by Anna McLean, Amy Ross, Beth Chatelaine, Morgan James Tressida, who have subject expertise, have a widespread knowledge of the machinery of government and also the parliamentary process. Electronic copies of submissions will be released on the People's Select Committee website after the hearing scheduled today. Media are present and submitters are free to decide whether they would like to comment on their own submissions after their presentation to the committee. The committee would like to take a moment to acknowledge the women, the champions in whose footsteps we follow, irrespective of their position, role, contribution or ethnicity. Those courageous leaders, past and present, who have advanced women's rights, women's work and pay equity. They are the sheroes of this kaupapa. They are us and we are them. A little bit of housekeeping. We're in a public setting, and in the event of a fire emergency, please follow the directions of the designated warden, who will walk calmly to the door and direct us outside. If in the event of an earthquake, we all know, drop, cover and roll, but most importantly, do not panic. I'd like members of the People's Select Committee to take a moment to introduce ourselves, and we'll start to my right.
Morena, I'm Marilyn Waring. I was the 15th woman Member of Parliament, and I was there from 1975 until 1984. And these days, I pretend I'm retired.
Kia ora koutou katoa. My name is Leanne Dalzell. I was a Labour Member of Parliament from 1990 to 2013. Double her, I was number 30, the 30th woman Member of Parliament, and 2 years of my time in Parliament I spent as Minister for Women's Affairs.
Kia ora, my name is Ria Bond. I was a Member of Parliament for New Zealand First in 2015 to 17.
Kia ora koutou. My name is Belinda Vernon, and I was a National Member of Parliament from 1996 to 2002.
Kia ora, I'm Lynn Pillay. I was a Labour Member of Parliament from 2002 to 2011, and prior to that I worked for the Nurses Union and campaigned for pay equity about 35 years ago.
Kia ora, ko Joanne Hayes tōku ingo. My name is Jo Hayes, and I was a member of the National Party between the years of 2014 and 2020.
Kia ora koutou. My name's Sue Bradford, and I was MP for the Green Party from 1999 to 2009. Kia ora.
Kia ora koutou. I'm Steve Chadwick, and I was a Labour MP from 1999 to 2011, and was privileged to hold the position of Minister of Women's Affairs.
Kia ora koutou, I'm Jackie Blue. I was a National Member of Parliament from 2005 to 2013, and following Parliament I was the Human Rights Commissioner for Women's Rights for 5 years. Thank you.
Kia ora, Nanai Mahuta. I was a Member of Parliament for the New Zealand Labour Party from 1996 to 2023, and the portfolios that intersect with this kaupapa that I was proud to steward through was the Ministry of Youth Affairs and Māori Development. On that note, we'd like to thank all submitters for the time you've taken to share your insights and expertise. Please take your submissions as read and do not feel like you need to speak to every point. The members have questions prepared for each of you, and we want to make the best use of your time and expertise. Can I now call on Traci Houpapa to present her submission? Thank you very much. We've scheduled 20 minutes and we'll be in your hands as to how you would like to conduct the discussion, but your submission is taken as read.
Kei te tautoko haunga mihi kua mihi ngā kōrero kua kōrero tia. E te tiamana o te tepu, tēnā koe, huri noa ki ngā mare kura o te motu, a tēnā no tātou katoa. It's an honour to present on pay equity principles in my respective roles as the former Crown Facilitator for the Reconvened Joint Working Group on Pay Equity Principles in 2017 and over the top to 2018, and also as the Chair of the National Advisory Council on the Employment for Women. And in terms of my time, Madam Chair, let me start for the first part of this time together to talk to the Reconvened Joint Working Group, and then I would like to invite my colleagues to join me for the NACU presentation. My name is Traci Houpapa. I have a background in strategic and economic development. I'm a professional company director and serve on a number of companies, entities and advisory groups here in New Zealand and internationally. As the Crown Facilitator for the Reconvened Joint Working Group, what I want to talk to this morning briefly to put on record the value and key lessons from the Reconvened Joint Working Group on Pay Equity Principles, and to focus more on how open engagement and meaningful consultation between unions, employers or business and government led to constructive outcome-focused approaches, and also to recommend how those lessons should and must shape ongoing and future pay equity work. This group demonstrated that where parties commit to genuine dialogue, shared facts, clear processes and transparent governance, practical, durable solutions for systemic pay inequity can be achieved. The guiding principle that we subscribed to as a working group were really three interlocking principles. And they were respectful partnership between unions, businesses and employers and government as equal stakeholders acknowledging our respective and quite different roles with common purpose and agreeing on principles for pay equity. And also openness and transparency to the extent that we were able in terms of our respective organisational roles and commitments. And then as importantly, and I think this is an important fact, practical fairness so that we focused our solutions on outcomes for workers and businesses, and I stress that point. Fair pay for comparable work, and implemented ways that were administratively workable and sustainable. These principles were not theoretical. They were not fluffy or fudgy. They were arrived on through respectful discussion and debate. They shaped the group's process for design and framing of engagement and finalised the structure agreed outcomes. The agreed outcomes and shared approaches were important because we landed on and agreed on a definition of pay equity. We looked at a standardised assessment framework. We confirmed timelines and prioritisation that was reasonable and real. And we also looked at support mechanisms for employers regardless of size. We also learned the lessons that to start with shared facts, to look at a design process that had all parties participating, to be transparent about trade-offs or compromise or areas where we were in disagreement on so we could agree. And then we also looked at support for employees and employers, and I go back to the concept that employers and employees both have shared interests in the process. The 2017-18 Reconvened Joint Working Group demonstrated that pay equity is not a zero-sum contest between employers and workers. It is a problem that benefits from cooperative design and shared implementation. Open engagement, thorough consultation, and agreed practical approaches produced a map that, in my opinion, is both fair and workable. We strongly recommend, or I strongly recommend, that current and future policymakers and stakeholders adopt those core practices and principles. Shared evidence, transparent consultation and engagement, staged implementation and support for employers and employees, and independent monitoring as a standard approach to advancing pay equity. Embracing these methods will not only accelerate progress, because who wants to have this repeated conversation, but will in fact build partnerships and trust necessary for enduring and systemic change. Madam Chair, I leave the rest of the time for questions on the Reconvened Joint Working Group. Thank you.
I'll take questions from around the table. Stevie?
Well, Tracy, and thank you for coming and representing the Joint Working Group. Just a question of process since the repeal of the Act. Have you been asked to reconvene?
No.
Have you had any contact at all from government?
No.
Thank you.
Sue?
Kia ora. Thank you very much for this amazing submission. I'm just wondering, with your you've obviously worked with workers and employers and cross-sectorally and continue to do that. Do you have any sense now of how employers have felt about what the government did this year?
Yes, I have that sector-wide experience. I chair commercial companies and asset holding companies, both here in New Zealand, and serve on international companies as well. The general mood and feeling was one of shock with the changes, and also the fact that we live in a time where we recognise our women. And the important role that women play, not only as employers but also as employees. Further, we recognise, the boards that I'm on recognise that 50% of the population are women. Yes. And so that means that our target consumers, our market, reflect that pink dollar. And so being able to, ensuring that as good business owners and employers, and also as employees, we create a space where both business and employees can excel is an economic imperative.
Lynn Pillay?
Almost a supplementary, Tracy, and thank you for a great submission. You travel a lot and have been on a number of gigs over many years. In light of the pay equity legislation, when you're internationally, I mean, obviously we were very proud of it, but did it have significance in terms of your travels overseas with other countries?
Yes. Internationally, Aotearoa New Zealand is known for its commitment to Te Tiriti o Waitangi, its commitment to women, and as we all know, as Camellia Wearers, being the first in the world to give the vote for women. It has been surprising around the international tables that I've sat on that New Zealand would go backward on this particular matter, especially when it was such an important factor in recognising both the relationship between employers and employees, and also recognising how important pay equity is as an economic enabler for communities and families, which are the building blocks for our nation.
Can I take a moment to ask a question while members are considering theirs? You made the point that you provided support mechanisms for employers regardless of size, for SMEs in particular. Could you give us perhaps a stronger insight as to what types of mechanisms would have helped our SME sector?
We were clear with the Reconvened Joint Working Group that the process, the pay equity claims process, needed to be an agreement between employees and employers, Madam Chair. I think there are other people in the room who will be presenting next who might provide more detail on that matter.
Can I just have the supplementary on that, because in your summary report you also talk about the necessity for regulatory and support agencies to have the necessary skills, training, knowledge and resources to effectively support the resolution of pay equity issues. And we're aware, for example, that the pay equity unit was disbanded over a year ago, but this would have been the kind of support that you were talking about?
Yes, absolutely, because we recognise that the pay equity process for many was complicated, and we wanted to smooth that process. And we also wanted to ensure that there was, and that we could build capacity and capability in understanding pay equity claims and also the process.
Thank you.
Any further questions, Belinda?
Tracy, in the appendix to your submission, when you compare the changes, in relation to the comparison methodology, you note that the previous Act, or the 2020 Act, was unclear about how to take into account relevant non-sex-based factors. So was that a problem with the 2020 Act? And if it was, how would you have addressed that particular issue?
What we were clear on for the comparators is that we needed to, had we followed through with the process, then that would have been another piece of work that we could have explored and clarified. That didn't happen. Kia ora.
So, Tracy, I think your submission was terrific, so thank you very much for doing that. The 2020 Equal Pay Amendment Act was groundbreaking and hailed around the world as being, visionary. Then 2024, the Pay Equity Task Force was disbanded, and quickly in 2025, in May, very quickly, we had the amendment, 2025 amendment, which was a retrograde step. How long what's your sense of when did this start developing as an agenda item for the government or the incoming government, that they were going to actually repeal the 2020 Act and put in their own version?
In my roles, Jackie, I'm not aware or wasn't made aware of that process. I understand from the information that's been made available in this last week that was soon after 2022-23.
Right.
Again, and if you look at the time and what the experience, this positive and successful experience that we had with the Reconvened Joint Working Group, having reconvened a working group of time to engage on those matters to consult with women and interest groups and stakeholders would have been the appropriate course of action.
Would you like to take a moment to call your NACU colleagues up?
Thank you. Yes, please. Thank you. Madam Chair, I'm joined by Bernadette Pereira on my right, a long-serving member of NACU, and also Melissa Ansell-Bridges, who is also a council member on NACU. And it's an honour to change hats and pace quietly, and then to present on the submission from NACU. Again, we take this as read. NACU is an independent ministerial advisory group to the Minister for Women. It was established in 1962, and for the record, NACU's worked to address immediate employment needs, identify emerging employment issues, and commission research over that time. The NACU expresses its serious concern at the recent actions taken by government to weaken pay equity protections, including the abrupt cancellation of live pay equity claims by over 180,000 workers, the seeming rollback on legislative provisions, and the lack of transparent consultation with women, Māori, unions, and key stakeholders. These changes represent a step backward for gender equity in Aotearoa, New Zealand, and undermine decades of progress toward fair and just employment outcomes for women, and importantly, breaches of trust and confidence of women. NACU believes that good, fair and just employment conditions are mutually beneficial for both employees and employers, and can be best achieved through open engagement, consultation and discussion. Given the government's approach to pay equity changes, NACU was not approached for advice or comment. Based on the limited information available, NACU would have provided or recommended that government convene a working group of business, Māori, unions and key sector stakeholders to discuss and advise on benefits, impact, risk and value of the proposed changes. As mentioned in earlier submissions on the Reconvened Joint Working Group, where parties commit to genuine dialogue, shared facts and clear processes, practical and durable solutions to systemic pay inequity can be achieved. We have met as a council, and we have also met with NACU partners. We also are recognised leaders within our communities and sectors, and the concerns raised are these: that the cancellation of active pay equity claims, particularly in health, education, care work that have been halted or invalidated, have caused concerns regarding due process or engagement with the claimants. The legislative rollback, concerns were raised around key amendments to the Pay Equity Act, which have reversed mechanisms that allowed for cross-sector comparators, a simplified claim process and strengthened employer obligations. And also the lack of consultation, which I discussed earlier. No meaningful engagement occurred with women, workers, unions, Māori, Pacific and ethnic organisations, importantly disability advocates or gender equity experts. And these have had a net tangible negative effect, where women in female-dominated sectors have lost a vital legal avenue to challenge systemic undervaluation. Māori, Pacific, ethnic and disabled women who are overrepresented in low-pay essential work have been disproportionately affected, and trust between government, workers and advocates has been eroded. The outcomes of these actions serves to undermine women's rights, ignore established evidence and research, arguably silence women's voices, and reverse progress on gender equality. NACU opposes the cancellation of pay equity claims and the weakening of pay equity legislation. In the first instance, because of the lack of a transparent and open process of engagement and consultation with the key groups. Had these groups been engaged, it is NACU's view that a stronger, more resilient result in the interests of employees and employers could have been achieved. NACU urges the government to urgently and immediately reinstate cancelled claims and honour the legitimacy of existing claims and allow them to proceed without obstruction, to restore and strengthen legislative protections, to engage in genuine consultation, to undertake an independent review, and to reaffirm a commitment to gender pay equity. In conclusion, the rollback of pay equity protections is at best a policy misstep. At worst, it is a direct threat to the economic security, dignity and rights of women across Aotearoa today and in the future. NACU calls for an immediate course correction to prevent further harm and ensure that our country upholds its commitment to fairness, justice and gender equity in employment for women. Government must recognise that women's work has value and can positively impact the economy, and that equity delayed is equity denied. Thank you, Madam Chair.
Thank you. Able to take questions for this part as well?
Tracy,
Jackie?
Thank you so much again. Clearly, what you've stated is, I hope happens. It certainly needs to happen. In your submission, you talked about deliberate action needs to happen. Apart from repealing the current Act, what are the deliberate actions or affirmative actions that you see are the priority?
From a NACU perspective, we would, as I mentioned before, look to convene a working group immediately. And that needs to be chaired by an independent, and that needs to have full authority to engage and consult publicly with women, unions, business and key sector groups, as well as provide advice to the respective presiding ministers on this matter as a matter of urgency.
Thank you.
Any further questions?
And it really follows on from, you know, your beginning point. 1967, you've been providing advice either through the Department of Labour originally and then through to the Women's Affairs in 2012, and always to be there to represent a voice so that it was heard at every level. So I'm struggling to understand why you wouldn't be involved, but then I haven't gotten over the fact that the Ministry for Women wasn't involved either.
Yes.
It wasn't a very good question, was it?
Just very quickly, in your submission you talk about the social workers' pay equity settlement and about the change in the perspectives by employees. Now, I understand some of that research also reflected on a change in employers. Would you like to talk to that?
Dame Marilyn, we think that matter is best left for the next submitter.
Okay. Thank you.
And with that, thank you very much for your submission and the clarity of the outline that you provided to the committee. Can I just note that if the committee had further questions, supplementary questions, is it okay if we can follow up in written form by email for a request for
Most
information?
definitely.
Thank you.
A copy of the oral submissions as well.
And are we able to secure a copy of the oral submission
Yes.
as presented today? Thank you.
Thank you.
Tēnā koutou katoa. The next submission is the New Zealand Council of Trade Unions. No mai hara mai. We'll leave the time fully in your hands and questions will follow.
Ko koutou katoa. Ko Melissa Ransom-Bridges aho. I'm the Secretary of the New Zealand Council of Trade Unions Te Kauae Kaimahi. Joining me today is also our President, Richard Wagstaff, our pay equity lead, Morgan James Tresidder, and our gender justice campaign coordinator, Latavia Totai. The New Zealand Council of Trade Unions is the peak body of the New Zealand union movement. Collectively, over 300,000 working people are a part of the CTU. Whānau, we are the largest democratic organisation in the country. I'd like to start by thanking the committee members for your many years of service and ongoing commitment to your communities, and also thanking you for volunteering to take this time to do this work, which I'm sure we all agree should properly have been done by the government itself as a part of a proper democratic process. I'll take our submission as read. I have some statements to make, and then I will hand to Richard, who was the union lead in both the original and the reconvened working group, to make some statements about the work of those groups too. Suffice to say, this legislation is a demolition job. The resulting system is a series of hurdles and barriers masquerading as pay equity. Workers with legitimate claims of inequitable pay because of gender-based undervaluation now face a system seemingly designed to prevent genuine pay equity settlements. The only conclusion one can reach when looking at the totality of these changes is that they have not been made with the goal of leading to better outcomes for workers in these industries, but rather to stop in their tracks the claims and ensuing increase in wages the government would face. It is clear from these changes and from the secrecy with which they were brought about that the government knows that New Zealanders support pay equity and would not accept these changes. They have done everything they can to dismantle the pay equity system short of removing the legislation wholesale, the intention of which would not be able to be hidden. What was once a relatively straightforward, albeit occasionally lengthy road, is now one filled variously with potholes, roadblocks and dead ends. The government continues to insist it's a road, but it's not one that anyone can travel along anymore. And that, unfortunately, seems to be the whole point. I'll take some time now to highlight the changes which will have the greatest impact on the likelihood of claims succeeding. Firstly, changing the test from arguability to merit means some claims will simply never be able to be started, not because they lack merit, but because the evidentiary requirements cannot be met without already having commenced the process, creating a catch-22 situation. Workers such as some social workers and high school teachers, who most certainly are paid gendered wages, are prohibited from initiating claims because the threshold requirement has changed from 60 to 70% of women in an industry. There is no logic to changing this threshold, except to exclude these large groups of workers and avoid footing the bill for their pay corrections. Gendered undervaluation impacts sectors of workers, not workers employed just by one company. So a strength of the previous system was the ability to undertake multi-employer claims. This is a logical necessity for such a system. Now, though, employers can walk away from such claims without needing to have or give any reason. This can mean significant work could be invested in progressing a claim simply to have employers walk away at the last minute. Even where that doesn't occur, the ever-present threat would loom large and potentially encourage workers to accept a worse deal for fear of the whole process being abandoned. The narrative from government that it is nonsensical to compare social workers with air traffic controllers or librarians with fisheries officers implies that the comparator process considered those jobs to be the same. Either we are to believe that the government simply doesn't understand commonly accepted job evaluation systems which compare skill, responsibility and degree of effort, which we do not, or we must conclude that they are choosing to rely on the very gendered assumptions about the value of certain types of work, which the pay equity system is designed to correct, in order to confuse the public's understanding of the issue and justify doing away with it. The changes to the comparators process have resulted in a system which makes it practically impossible to make comparisons between male and female work. Effectively, undervalued work will now only be able to be compared to other similarly undervalued work from the same employers, occupations and sectors where gendered undervaluation drives inequitable pay. But these near impossible requirements are combined now with the new employer right to decide that no appropriate comparators are available and consequently discontinue the claim unilaterally. The combined effect of these changes almost guarantee that claims will either A, not be able to be started, B, will be abandoned by employers, or C, on the rare occasion that they are settled, will almost certainly lead to a lower value pay correction than what those workers would have previously been entitled to. Those workers and all those who have previously settled claims are then required to wait 10 years during which their rates of pay will become more and more inequitable before they must begin the process from the start again. The old system has not been replaced with a workable and sustainable alternative, but a farce. A workable and sustainable alternative would have nothing to hide. A workable and sustainable alternative would have been consulted publicly and with key stakeholders, would have been celebrated by government and followed a proper parliamentary process with a select committee held over the road. Not rammed through overnight with zero advanced warning or consultation and truly extreme lengths taken to avoid the public getting wind of it in advance. That process speaks to a government determined to hide it from the public until it was too late for anything to be done about it. It speaks to a government knowing its arguments don't hold water and its actions won't be supported. It speaks to the shame felt by this government, whose job it is to look after the interests of all New Zealanders as they strip away half our population's access to their fundamental rights and to money that is rightfully theirs. The New Zealand Council of Trade Unions recommends that the legislation is reinstated and improved upon with proper input from stakeholders, including working people, their unions and pay equity practitioners, and that the claims that were extinguished are reinstated and fast-tracked to fully funded settlements. You'll hear throughout the Select Committee process from many working people who've been directly impacted by these changes. You'll hear their grief, frustration and anger, their sense of betrayal. Theirs are the voices who must be centred in this conversation. Had they been called upon and listened to by this government, this charade would have been stopped dead in its tracks. Thank you for giving them a space to be heard. Madam Chair, we're happy to take questions. But I might pass to Richard Wagstaff first to speak to the working groups.
Thank you, Melissa, and thank you everybody for being here to take this information. I just want to give a little bit of sense of the flavour of the working groups and what sort of happened in that period, which might be helpful, that I can best recollect. So first of all, and we heard from Tracy earlier, the working group itself was highly consensual. Like we actually took a problem-solving approach. We deliberately said, what's the problem, what are we trying to achieve, how do we get there? And it was, I think, quite a bit of a breakthrough for many of those processes. And we reached consensus on just about all of it. Late in the process, the concept of a hierarchy of comparators was introduced, but we couldn't. That was the one thing we didn't agree on, and you'll see that in the report, in the letter that went from Patsy Reedy to Parliament. But otherwise, we agreed on things. There was an issue around merit. We're saying, how do you know if it's a pay equity claim or some other kind of claim? And we wrestled with how do we make that an easy thing to do. So we tried the concept of merit, but we always said it was meant to be a light, simple, triaging, light touch approach. What was happening while we were in the working group was claims were being progressed in good faith with the government of the day and with all of us along the lines of what we're promoting in the working group. We weren't waiting for the working group to be finished, we were getting on with using that approach. And what we found was, in fact, merit was being misunderstood from what we intended it. It was meant we're trying to promote a light touch approach. So when the working group reconvened and said it should be arguable, it actually wasn't a change of mind. It was just a change of practice, because we said, people have misunderstood what we mean by merit. Let's give it, what's the simplest, lightest touch triaging kind of concept we can use? We came up jointly with the word arguable. So that wasn't a change in position at all, it was just a change in what you called it. So in my view, it was always agreed that it was arguable. We tried merit, it didn't work as a title. And the hierarchies were never agreed. What is important though, is that the report did say comparators may be used so long as the comparator is not distorted by being undervalued due to the systematic undervaluation due to being women's work. So there's already a notion that you couldn't compare with distorted jobs, and hence the idea of a hierarchy. That was why we argued that it just doesn't make sense, it's incongruent. What happened after the first working group, as you'll know, was the legislation was introduced by Michael Woodhouse. That contained merit, even though we knew it wasn't working. That contained a hierarchy of comparators, and that hence when that was when there's a change of government, then the new government said let's reconvene that working group and recommend changes to the legislation that Michael Woodhouse introduced. What I'm finding, the last point I want to make is, right now, we hear defenders of the changes saying, oh, we're just going back to the consensus in 2017. We're just going back to that. I want to be really clear that it's nothing like it. First of all, there's no consensus on Michael Woodhouse's legislation. Secondly, even if you take that legislation as it is, there was still a review period, even in the 27 legislation we didn't like. There was still back pay. There was no cancellation of existing claims. There was no ability to opt out. And in fact, the hierarchy has got even worse than what it was then. So it's wrong to portray it as some kind of going back to 2017. We didn't agree it then anyway. But even if we did, it's still not that. It's much, much harsher. And in fact, when we did the Reconvened working group, we were unanimous saying that arguable should be there instead of merit. And we were quite clear that the hierarchy just didn't make any sense. So I just wanted to give a flavour of those working groups. Thank you.
Thank you very much for that clarification. And just to remind members, if you could tilt your, just so I can keep track of all the questions. I'll take questions now. Okay, Belinda.
So in your summing up, you said you recommended a repeal of the legislation and then of the last lot, and then improvement. So what are the key items that you would want to improve in the former legislation?
I think that actually the key there is that process is one that should happen through a working group. That process of consultation and tripartite, workers, unions, government, working together has proven to be effective to reach consensus. That is the process that should be followed again to find out what improvements could be made to the legislation. Thank you, Belinda.
Leanne and then Lynn.
Because I'm trying to get to the bottom of the why. I mean, you can look at it and you can say it's the money, and the timing would indicate that was it. But I think there's more to it than that, isn't there? And it's to do with the wage bargaining process and what you have described this morning as a balanced collaborative approach, which looked at both sides, conducive to constructive dialogue aimed at bringing about resolution. These are words from your submission, and it seems to me that approach is not something that, that is the only way to achieve pay equity, I guess is what I'm trying to say. So do you think there's more to this than the money? Is there something about undermining the actual process as well?
No doubt that all of the changes indicate that. I do think that all of the changes which undermine the process, which devalue and de-emphasise the role that the impacted workers have in the process, all of them take power from the workers in that process to be able to contribute to the settlements. So there is a disempowering aspect to the process that's been brought in, but ultimately all of those, again, will have an impact of less money going to working women.
Yeah, but do they not like the tripartite process?
I think ideologically that's very clear. Yeah, absolutely. Because if there was a valuing of that tripartite process, which is an internationally accepted process, that is how the ILO operates, that is how our strongest economies around the world operate. They recognise that unions and employers and government, when working together, will get the best solutions for everyone. It's not just for working people, but for employers as well. But ideologically, it would seem that this government is opposed to that concept, and that is definitely borne out in all of these changes as well, and the process that was followed to get to these changes too.
Which is why the collective, the extended coverage is gone.
Lynn and then Sue. And
Thank you for a great submission. This is almost a supplementary because, definitely the PSA in particular have, over the last couple of decades, really had a lot of inroads into more collaborative bargaining, and it's had amazing results. But to be honest, when we received the presentation on the pay equity process, I was quite blown away about the degree of trust that developed. And without too much on it, could you make a comment about how perhaps on the first day, what it was like, and how things moved in terms of the constructiveness of the working relationship?
Absolutely. I might actually pass this question to Morgan, who is our pay equity lead and has also been a pay equity practitioner for a number of years.
Thank you to the committee. So I think, as Leanne mentioned, like the traditional bargaining processes can look quite adversarial, and I think that for a lot of processes that you might start out like that, but it did look quite different in terms of working together over time, going out and interviewing claimants together, having the employers and unions work together to really get a clear picture of what the work looked like, which for some sectors was something that hadn't happened before. And I think when you get to that kind of level of consensus where you're getting people to see really the same things, that it's quite a lot easier to work together to find solutions, because everyone has a really clear understanding of what the problem is.
And just very quickly, in terms of the employer-employee direct relationship, that probably would be highly enhanced by this process too, back at the workplace sort of.
Yes, yeah, and I think, as noted in some of the research into the social workers claim, the level of respect and value that the workers felt once they got those settlements, compared to how they felt previously about their job, it's quite clear to see that the impact is huge. Thank you.
Out of courtesy to our next submitter, we're going to keep on time, so my apologies to members. But should there be supplementary questions, are you happy for us to follow up in writing?
Certainly.
Kia ora. Thank you.
Thank you.
Thank you. Thank you.
Ngā mihi kia koutou. Our next submitter is Tracy Martin.
Thank you.
No mai hara mai, Tracy. Please take your submission as read, and we are in your hands. There will be questions to follow.
Kia ora. Tēnā koutou, tēnā tātou katoa, ko Martin te whānau, ko Mohi te whānau whāngai, ko Ngāti Kahununu, ki he tangata iwi, ko Tracy Takuingoa. My name is Tracy Martin. Thank you. I opened with Madam Chair, but I'm not quite sure what the plural is. But the dames, there you go, of the chairs. Firstly, can I thank you for the opportunity to speak on this piece of legislation. The Aged Care Association welcomes this opportunity to submit to the People's Select Committee on pay equity. A sustainable aged care sector cannot be achieved without properly rewarding the predominantly female workforce that sustains it. Chronic underfunding stems partly from historical undervaluation of care work as women's work. As I mentioned, I'm the Chief Executive of the Aged Care Association. We're the peak body for the aged residential care sector, and we currently represent close to 100% of that sector. New Zealand has over 670 aged residential care facilities, and with approximately 39,000 residents. We have around about 40,000 beds. Te Whatu Ora has just around 10,748 public hospital beds. So we are a significant workforce inside what is the healthcare for New Zealanders. Our members and their staff provide rest home, hospital, dementia, psychogeriatric, respite and palliative care, and care for around 700 young people with disabilities. 66% of those beds are run by religious institutions, charities, family-owned businesses, not-for-profits and community-owned trusts. Most of the remaining beds, 34% of them, are operated by listed companies, and 1%, under 1%, is operated by Te Whatu Ora. New Zealanders in our care may be very frail and clinically unstable, well but disabled and have very high care needs, cognitively impaired or with mental health issues, with some requiring a secure environment, and receiving end-of-life care. Funding for the aged residential care is a mixture of means-tested user pays and government subsidy. Providers are contracted by Te Whatu Ora to deliver care services at a rate that is set annually. For the 40% of senior New Zealanders living on superannuation alone, or the 20% who live on superannuation and just a little bit more, the government is the major funder. When government either removes funding or denies its responsibility to fund clinical care for its citizens and residents, we have an equity divide that develops, and we are seeing it now. Aged residential care is nurse-led with healthcare assistants, often referred to as care workers, working alongside registered and enrolled nurses to deliver highly skilled, hands-on and emotionally demanding care. Some healthcare assistants have enhanced their skills and specialise in supporting residents living with dementia and psychogeriatric conditions. This work requires a deep understanding of cognitive decline, behavioural changes, and the need for safe, structured and compassionate environments. In a single shift, a care worker, whether in general aged care or in dementia psychogeriatric unit, may provide the following: personal care with dignity, clinical support, which is monitor vital signs, assist with mobility, medical assistant, administer medications and support residents to take them, observing side effects or changes in health status, nutritional care, helping residents at meal times, adapting food textures for swallowing difficulties, ensuring hydration, specialist psychogeriatric care, using of de-escalation techniques to manage agitation, guide residents through moments of confusion, redirect behaviours that could cause harm and create calm, familiar routines that reduce anxiety. Emotional connection, offer companionship, listen to stories, maintain warmth and patience even in challenging moments. Family liaison, supporting families coping with loved ones' cognitive decline, providing updates, reassurance, practical advice. Emergency response, act swiftly in the event of a fall, sudden illness. Document everything. For care workers in dementia and psychiatric units, every interaction is shaped by the awareness of a resident's unique needs, history and triggers. This work blends clinical skill with empathy, patience and creativity, adapting care approaches on the spot, sometimes minute by minute. It is a complex, skilled and physically demanding and emotionally demanding work. It requires ongoing training, professional resilience and unwavering commitment to quality of life for some of New Zealand's most vulnerable citizens. Madam Chair. As the committee will know, the pay equity claim for the care and support workers was formally lodged by unions on the 1st of July 2022, marking the expiration of the previous 2017 settlement. This representative claim involved 15 named employers from across the aged care, disability, home support, mental health and addiction sectors. It was being pursued under the Equal Pay Act and was progressing through the multi-employer pay equity framework toward a potential sector-wide settlement. The word progressing is valuable in that sentence. We willingly participated in the pay equity claim for care and support workers because we believe those caring for older New Zealanders deserve to be paid in a way that reflects both the real cost of providing that care and the true value of the work that they do. In just the last 12 months, I estimate that our sector has spent close to or over $500,000 gathering information for that claim, much of it at the request of government. Yet while we were doing that, the government was already moving behind closed doors to get cabinet approval to end all current pay equity claims, including ours. No discussion, no public input. That's not just a waste of time and money for the businesses we represent. It undermines trust in government. Our key concerns around the situation that has arisen due to the legislation and its passing under urgency and in secrecy is the lack of good faith engagement. The Equal Pay Amendment Bill 2025 was not developed overnight. We now know that it took longer than 6 months before its announcement. Cabinet papers were being drafted, coalition discussions were taking place, and policy trade-offs were being made. During this same time, the parties to the Care and Support Workers Pay Equity claim, including the Aged Care Association, believed we were in good faith discussions with government agencies about funding a settlement. We invested significant time and resources only to find those efforts wasted. This breach of good faith will take some time and genuine effort on behalf of government to repair. This action also sent a strong message to our members that government acted with arrogance and disregard of the effect their actions would have, both before, during and after developing this legislation. Employer parties and peak bodies spent tens of thousands of dollars each complying with Te Whātua Ora's requirements that in hindsight appear to have been a deliberate delaying tactic. Working groups were kept in a holding pattern with repeated excuses, further straining already underfunded providers. The ACA and other peak bodies spent hundreds of hours surveying our members and compiling data for Te Whātua Ora, only to be told the agency would then use its own calculations. Why would our members be willing to participate in data collection requests from the government in the future if this is our most recent experience? Our members are already very busy caring for New Zealand seniors. Now, our members hold diverse views around pay equity. Nobody is a single voice, single tone voice. But the one thing we do agree on is the value of the care that is provided, and that care counts. Our society and our sector depends on the dedication of nurses and healthcare assistants. Providers want to pay fair wages that reflect the true value of care. However, this is impossible when the government's funding models are not based on evidence and do not reflect the actual cost of care. On the 20th of May this year, the Minister of Finance responded to oral questions in the House stating, when the member discusses the funded sector, what she is talking about are private sector employees, some of whom are listed profitable entities on the New Zealand Stock Exchange. This was in response to a pay equity question. She went on to suggest that government should not involve itself in what she called a discussion between business and workers, implying our sector, with a focus on listed companies, should resolve pay equity on their own. This sort of statement ignores that 60% I mentioned earlier. And even if it were true, why should business, profitable or otherwise, be expected to subsidise the state's responsibility to provide clinical care to its citizens and residents? We are and will continue to advocate for the development and implementation of an evidence-based funding model that ensures the government pays the actual cost of clinical care for older New Zealanders who have been assessed as needing it. And this includes paying healthcare workers the true value of their work as New Zealanders, not less simply because they are women. Madam Chair, I'll close, but I would just say that we will continue to advocate for recognition that the women that work inside our sector, if you listened to the jobs that they do, the skills that they have, you could immediately go out yourself and find a male-dominated sector that is required to have the same skills and that could not be employed at the price that we are currently paying our care workers. But we cannot do it if the government washes its hands of its responsibilities. Kia ora.
Kia ora. There was a fulsome submission, and in the time available, I will take 2 questions from across the table. Jackie?
Tracy, thank you. In light of the current Act and the cancellation of your claims, where do you see what's going to happen with your workforce?
Yes, it's very challenging for our workforce. Our particular claim is one of those that falls under the 10-year. So while we understand our in conversations at the moment with union representatives around what is possible, the legislation itself makes it look very difficult that anything is possible. So we will try to advance benefits for our workforce through the work we are doing with Te Whātua Ora and evidence-based funding, at the same time while not giving up on government recognition of pay equity.
Marilyn?
Thank you. Thank you very much, Tracy. I hope we'll be able to have your notes, because I just want to say that when you did that description, these are the skills that are required. That's incredibly helpful. Thank you. You know what this question... Is your organisation a member of Business New Zealand?
Yes, it is.
And did Business New Zealand ever ask you for your attitudes or responses to pay equity?
Unfortunately, I'd have to come back to you with an answer on that. I've only been employed for just over a year in this role, and I would imagine that because this has been going for some time before being cancelled, that there was possibly an opportunity for Business New Zealand to reach out to us at the beginning. So if you don't mind, can I come back to you in writing?
Yes, thank you.
Kia ora.
Thank you for your submission, and would you be happy for us to make further information requests? And could we have a copy of your oral, any notes that may have assisted your oral submission?
Kia ora. Thank you.
Thank you. Our next submitter is Dame Sylvia Cartwrite. Tēnā koe e te manukura no mai hara mai. Kua ki te mai te whakahaeretanga o tēnei committee. The time is in your hands and we will follow with questions. Welcome.
Good morning, Morena. It's a great honour to appear before the People's Select Committee today. Mine's a very boring submission. It's focused on the law. My primary concern as a former judge and lawyer is the retrospective effect of this legislation. Most people will understand that there is a general principle now contained in, well, has always been contained in legislation, but most recently in the Legislation Act of 2019, that legislation does not have a retrospective effect. Now, obviously, most legislation does because it changes what happened in the past to introduce new policy, new procedures, new ways of thinking. But the retrospectivity of legislation that the courts have always found unacceptable is if it affects rights that were had in the past that have now been cancelled or affected in some way. Now, the general principles are that legislation that has a retrospective effect is generally considered inappropriate if it undermines key legal principles such as fairness, legal certainty, and the rule of law. Now, I'm very strong on the rule of law. I've long been involved in international law, and currently, as you'll all be aware, the whole issue of the rule of law is being undermined all around the world, not just here in New Zealand. And as a general explanation of what the rule of law means, it's that public powers act within the constraints set out by law in accordance with the values of democracy and fundamental rights and under the control of independent and impartial courts. Now, I read that out because currently I chair the board of the International Commission of Jurists, and I spent 2 terms on the CEDAW committee, the Women's Convention Committee. That was last century, so it's a long time ago. But in both those areas, New Zealand has always had a very high reputation for upholding and promoting the rule of law. And I can recall during my CEDAW years the shock that the committee had that New Zealand did not have paid parental leave at a time when the Scandinavian countries were trying to force their men to actually take the parental leave that they were entitled to. We didn't have any paid maternity leave, let alone parental leave. I predict that this issue will become something of significance internationally. And we can't ignore our international reputation. It's been hard won. We are highly regarded, and this is something that I think that this legislation will undermine. In fact, I've got no doubt about it. Now, the other issues, the other principles of fairness and legal certainty, well, our courts obviously have had something to say on this topic, and I quote from a 2016 judgment of the Court of Appeal, which talks of, which says that the Act, that is the Legislation Act, instructs courts to presume that the legislature does not ordinarily intend that legislation should affect accrued rights. The legislature also recognises as a matter of policy that retrospective legislation should not affect existing judgments and proceedings unless the legislative purpose necessitates it. And as to the court's comments on fairness, in a case, Foodstuffs and the Commerce Commission, discussing the 2019 Interpretation Act, the court said that the legislation has long recognised the need to strike a balance between giving effect to Parliament's will aimed at changing the law and introducing new policies on the one hand, and on the other hand, to protect, for reasons of justice and fairness, positions already established under the old law. So the common law, the courts, emphasise that we must accept that legislation changes law and changes positions and entitlements, but it should never do that retrospectively. And in fact, it's quite hard to find instances where this has happened in the past. I want to go through some of the areas in this Amendment Act that actually remove or dilute existing rights or rights and entitlements that existed at the time the Act was passed. And some have been mentioned already, but according to the public records, all 33 existing claims under the prior law have been stopped as the result of the Act's retrospective nature. Now, I predict there's going to be significant amounts of litigation around whether this is a proper approach to take or not. Secondly, some rights to appeal or to challenge claims already underway have been modified. Then there's a higher threshold for a claim, and we've already heard this touched on. Work must be performed by at least 70% of female workers who have been there for 10 years. So it's a major hurdle to cross compared with the 60% threshold that was there previously, and that had no time constraints attached to it. The courts are going to have fun with this one. Stricter evidence is required. The work must now have merit. That means proof. You must gather your evidence before you actually get it to the court, compared with the arguable threshold, which simply means, as we lawyers say, the prima facie, on the face of it, there is an arguable claim. So it's a much higher standard now. It'll be much more difficult to persuade a court. And of course, there are many stricter provisions for the selection of comparators. This is a very difficult area, but they're now largely limited to comparators within the same employers or industry, which is kind of reinforcing, if the women are low paid, it's kind of reinforcing that low paid, because you can only go to the same industry. As has already been noted, you can't go across to another field which has similar skills, perhaps similar education, perhaps similar levels of danger or whatever, but are not female dominated. So now you're comparing female dominated industry, or you prospectively comparing female dominated industry with female dominated industry. So we are actually, in my view, it'll be a sinking lid on female pay rather than a fairness approach. Employers have an increased power to resist claims, so we're simply making the playing field much less even for women who want to take pay equity claims. and back payments and review rights have been restricted. One of the areas that I find difficult is that you can no longer agree between the employer and the employee to have a review right in your agreement. That is taking away a right to have a discussion across the table and say, well, look, we can't afford it this year, but in 5 years' time we will have a review, and you're not even allowed to do that anymore. So basically that is my submission. You already have my very brief written submission. But I am very concerned that this legislation undermines those key legal principles of fairness, legal certainty, and the rule of law. Now, don't ask me too many questions.
In the time available, we will take a couple of questions. Thank you, Dame.
Excellent submission. What legal challenges are there that can be to this Act? What legal avenues are there?
Well, I'm struggling a bit because of the many dampening effects of this Amendment Act. But I do predict there's going to be a great deal of litigation as groups try to find what is the new what are the new basic principles here. And I very much have concern for when previous submitters said that they've gone to make things fairer, but it's going to be very difficult. And I was a legal administrator at one stage in my, judicial administrator at one stage in my career. The courts are not going to be happy about this because it's a complete change in the law. It's going to take longer, there'll be more claims, there'll be more attempts to get around these provisions. And so it's going to cause problems in areas that weren't really thought of, in my view. So I'm not quite sure how it's going to be achieved, because I haven't been a litigator for many years, but I can see from the court's point of view this is going to be very difficult indeed.
One final question from Dame Marian.
Silvia, are there circumstances in which retrospective legislation might be justified?
Yes, yes, there can be cases. It's been quite hard to find examples where existing rights have been eroded, in the sense that people who have an existing claim can no longer pursue that claim. This is very unusual legislation, very unusual. But it seems to me that the general principle would be where it's acceptable by and large to the public that previously held rights are to be changed. And that implies, of course, then you need to have select committees and so on to hear what the public's views are. But there is one really good example, and that's, this is in the area of criminal law, of course, where there were retrospective changes, and that's in the Homosexual Law Reform Act of 1986, which decriminalised actions that were previously considered criminal and expunged criminal records. Now that's an area that I think most people, regardless of what you think about the Homosexual Law Reform Act, and I know it was very controversial at the time, it's no longer controversial, but at the time it was very controversial, but it was generally accepted that if it's now okay to engage in homosexual acts, then it's unfair to people who had previously been convicted. And another example, again a very controversial example, where existing rights were changed which did not have the complete public support, is the Foreshore and Seabed Act, which took away rights. They're very narrow rights. It was sort of using a hammer to hit an ant. They were very narrow available rights under the previous common law, but that took away those rights, and it was highly controversial and remained so for years, and I make no comment on current policy, but it remained so for years and ended in, of course, legislation amending that act. So it generally public acceptance that it's fair enough, and public consultation to make sure you've got it right. It would be my criteria. But it's quite hard to find legislation that has had this sort of effect.
Dame Sylvia, thank you for the lucidity of your submission. The committee appreciates your time and the clarity of perspective that you have brought to us. Thank you.
Thank you very much.
Ngā mihi. Our next submitter is Gail Pacheco.
Yeah.
No mai haramai, the time is yours and there'll be questions to follow.
Thank you. Tēnā koutou katoa. Thank you for the opportunity to speak to the committee today. I'm Professor Gail Pacheco, the Equal Employment Opportunities Commissioner at the New Zealand Human Rights Commission, Te Kāhui, Tika, Tangata, New Zealand's national human rights institution. And with me I have Oliver Cristello, my senior advisor at the Commission. We'll take our submission as read and use our time today to speak to some of the key points I want to iterate, and hopefully leaving some time for some questions at the end. I know it's already been said today, but I want to start with noting that in the absence of a conventional parliamentary process, we recognise and appreciate the setup of the People's Select Committee and its proactive approach to seeking evidence and perspectives on the recent amendment to the Equal Pay Act. Our appearance today is under our mandate to promote and protect human rights in Aotearoa and the human rights dimensions of Te Tiriti o Waitangi. I have 6 key issues I wish to raise. I had to number them. I'm an economist. I like my numbers. So the first of these is that the 2025 amendments undermine human rights. Equal pay for work of equal value is a fundamental human right. It was recognised more than 100 years ago in the Treaty of Versailles and is included in the Universal Declaration of Human Rights and the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. The recent amendments appear to be inconsistent also with Article 2 of the International Covenant on Economic, Social and Cultural Rights. Article 2 provides that state parties shall undertake steps within their maximum available resources with a view to progressively achieving full realisation of these rights. Such progress must be carefully protected against retrogression. That is, New Zealand is obligated and has committed to doing what it can to advance pay equity and is obliged not to backslide on this right. The second point is that the amendments restrict access to effective remedy. The right to access an effective remedy is a fundamental principle in human rights. Remedies must be accessible, effective, and capable of leading to redress. Collectively, the amendments have a serious adverse impact on access to remedies for breach of the right of equal pay for work of equal value. For example, the cancellation of 33 active pay equity claims significantly impedes access to remedy. In addition, review mechanisms previously agreed have been removed, thus eliminating not only a remedy previously provided for in the Act, but a remedy that was agreed between parties as part of resolving a claim. Furthermore, increasing the threshold for pursuing a claim from arguable to having merit and increasing the female workforce threshold from 60 to 70% both have the effect of making pay equity settlement harder to access. For some of these changes, they may remove access to the remedy entirely. So, for example, the Ministry of Education has reported that 64% of secondary teachers are women. So under this new threshold, their claim will not proceed. The third point I'd like to make is the importance of a robust pay equity process. The 2020 amendments introduced a process for people working in female-dominated professions to address underpayment due to systemic sex-based discrimination and historic undervaluation of female-dominated work. The process was designed to be robust and accessible with a low threshold to raising a claim. And by May 2023, 10 settlements had been reached, correcting pay for over 111,000 people, with pay correction averaging around 32%. More than 200,000 workers were subject to further claims. This process could, of course, have been strengthened further. For example, there are credible reports of workers having their hours reduced and workloads increasing following pay corrections. But instead of building on the overall success of the 2020 process, the amendments dismantle key features of the system. The fourth point is on the role of Te Tiriti o Waitangi. Te Tiriti is our unique statement on human rights in Aotearoa. It belongs to and is a source of rights for all people in New Zealand. Article 3 of Te Tiriti not only guarantees Māori freedom from discrimination, but also obliges the Crown to positively promote equity. Stakeholders have expressed real concerns that the 2025 amendments will disproportionately affect Wahine Māori and make it harder for them to pursue claims. And if correct, the amendments appear to be in breach of the Crown's obligations under Te Tiriti. Additionally, the principle of partnership requires the Crown to consult and partner with Māori genuinely, and the failure to involve Māori in consultation regarding the amendments again appears to be a breach of its obligation. The fifth point, and this is quite an important point I'd like to make, is on comparators. The ability to identify an appropriate comparator is at the absolute core of a pay equity claim. Pay equity means providing equal pay for work of equal value, even if the work looks very different. To do so, we compare the skill, the responsibility, the conditions, the effort required to perform, and that opens the door for a rational assessment of undervaluation. The amendments now impose a rigid comparator hierarchy. Employers first, then similar employers, then the same sector or industry. There's also no mechanism to move to a more flexible approach in assessing value if there's no comparator within your industry or sector. And the 2025 amendments provide that when an employer decides that no appropriate comparators are available for selection, the employer can give notice to discontinue the pay equity claim with certain rights of challenge to the claimants. In sectors that are female-dominated, like education, there may be few, if any, appropriate male comparators. These restrictions risk making it difficult to pursue a claim and make it significantly more challenging for example, the 90,000 workers covered by the discontinued teachers' claim. And that's for them to realize their human right to equal pay for work of equal value. The sixth and final point I want to make today is about the use of urgency undermining democratic participation. Consultation with affected people and participation by them are recognized as core to a human rights-based approach. Such an approach is aimed at eliminating discrimination, promoting democracy, and the legitimacy of public institutions, something that a few of the presenters have already talked about today. The bill was introduced and passed under urgency. The process excluded workers, their unions, employers, Māori organisations, women's groups, and pay equity experts from the process. The human rights analysis contained in the Cabinet paper relating to the amendments have been completely redacted, despite requests for this to be released. Not only do the outcomes of the Act raise human rights concerns, but so does the process. And as often is the case, one begets the other. So in conclusion, we recommend that the 2025 amendments be repealed, all discontinued claims and review processes be reinstated, and any future changes to the Act be developed through full consultation with the public, affected groups, Māori, and experts. The 2025 amendments reverse decades of hard-fought progress on pay equity, undermine democratic participation, and are inconsistent with Te Tiriti and international human rights obligations. Future changes must aim to advance, not undermine, the human right for equal pay for work of equal value.
Thank you very much for your submission. Can I kick off the questions with regards to the last point you made about the human rights section being rejected from the cabinet paper? How many times has this happened, and is it, in your view, a justifiable rejection?
Well, we've asked for that redaction to be released. We did it through an OIA process, and we got a response back that they wouldn't release it, that it wasn't in the, I can't remember the exact words they used.
It was rejected by legal privilege. And so it's obviously, I suppose I would only add, it's very hard to make an assessment of whether or not that rejection is justified without reading it. So it's sort of a catch-22.
And if you think about the public interest in this, given the amount of people that are covered by discontinued claims and future claims, the public interest is very high in this. We're progressing this through to the Ombudsman as well.
Jackie Blue?
Yep. Kia ora, Gail. Thank you for your submission. Has the Human Rights Commission considered applying to the courts to find that the current Act is inconsistent with the New Zealand Bill of Rights, or looked at going to international treaty bodies that we have treaties with?
Yeah, so we're in the process of looking at international accountability mechanisms, and we'll do that also through our international reporting system. So, for example, this year we've got the Convention on the Elimination of Racial Discrimination, CERD. I mean, I'd like to also note there, you know, in terms of one of the key mechanisms, the CEDAW, the Convention on the Elimination of Discrimination Against Women, which the last review happened quite recently in 2023, 2024. In the 2023 report by the government itself hailed the pay equity system as, I can't remember the exact wording, but hailed it as an outstanding piece in our work.
One more brief question. Thank you, Steve.
Thank you, Gail. That is a very important submission. But with the depth and the breadth of your connections, had you ever examined the coalition agreement? Were you aware of this, what we now see as Project 10? Were any of us aware that this may have been embedded in the coalition agreement?
No. That's the easy answer. No. No, I found at the same time, and also if you look at the Human Rights Act in terms of the role, the EEO Commissioner role is EEO Commissioner with pay equity, and my role is, according to the Human Rights Act, to lead discussions on matters of equal employment opportunities and pay equity, and to work with other government and other parties on equal employment opportunities and pay equity. That's in the Human Rights Act. But no, I was not aware of it.
Thank you very much for your submission, and we will take a short break. I will ask that members come back to the table at 10:27, so that's a 2-minute break. And we'll be back at 10:27 to commence our hearing at 10:28. Kia ora.
check 1, 2, 2, 2. That's good? Yep. Check 1, 2, 3, 4, 5. Check 1, 2. Hey, check 1, 2, 3, 4, 5, 6.
If I can call us to order, we'll resume the committee hearing.
A bit of a judge.
I'd like to call Marian Street as our next submitter.
Thank you. Kia ora koutou, ngā wahine mā. Ngā wahine toa ko Marian Street aho. I was the 93rd woman MP in our parliament, and I served from 2005 to 2014. It was my privilege to do so. And it is an even greater, dare I say, privilege to be able to present today on this critically important topic. I know you've read my submission. I'll take it as read. I've just got a few points that I want to highlight. And in advance of that, I just want to pay a tribute to all of the people who have gone before, who have contributed to the development of this pay equity movement. In my case, since the 1980s, and I've had the privilege of working alongside many of them, and whose names will go down in history sometime when that book is written. And maybe, Marilyn, that'll be something you could do as you look to retire. First of all, it would seem that pay equity is a concept not readily understood. I thought it was. That was my mistake when I saw this legislation. Since the 1980s, I have been involved with groups, first in Auckland, with the Auckland Working Women's Resource Centre for a long time, to explain to people what pay equity meant, and that it was, in fact, the comparison of the dissimilar, not the comparison of those within same low-paid jobs, same industries, same to same. It was the comparison of the dissimilar that was important. And that is important for a number of reasons, not the least of which being the economic status of women. There are all sorts of societal reasons why women have ended up in low-paid occupations. And as the decades have gone on, that stereotyping has been overlaid with a number of different appearances. So, when we were trying to educate people, including women workers in particular, about pay equity, and we went through the Hay methodology and the PricewaterhouseCoopers methodology, and we went into excruciating detail about all of this and got people to understand what pay equity meant. It was then a matter of defusing some of the anxiety that men in unions had felt about where we were going. I am tempted to tell an anecdote, but I won't. I haven't got time. But the point is that in comparing occupations on the basis of training, skills required, responsibility, the span of authority, all of those things, is a well-established methodology. It is not new. And so I am utterly perplexed, unless it is for the reason of willful blindness, that some of our politicians do not understand it. I would have thought over 45 years, which is what I can count anyway, over 45 years, they might have absorbed something by osmosis, if not by reading or research. That some of this would have sunk in. But no, it seems not so. And it is especially not so for the 180,000 workers whose claims were in train. I absolutely endorse Tracy Martin's cry before about the money that her organisation had spent on this, and I absolutely applaud her list of skills that Marilyn, you drew attention to quite properly. The injustice and the waste of time for those who followed the process is not justifiable. And of course, nobody can top Dame Sylvia with the legal things, but I just wanted to have it on the record that the retrospectivity of this gets right up my snout as well. That's a colloquial expression, excuse me. It is neither good, as we know, in principle in law, nor is it good in practice. I want to come to one bit of my own experience when I was a relatively senior manager in Kiwi Rail as the employee relations manager, and we were approached by a group who was putting together a claim for a pay equity claim for clerical workers in hospitals. And they were looking for a male-dominated occupational group. Well, they're not hard to find in Kiwi Rail. And came to me and I said, yes, would be happy to participate in this. The manager of our largest site, male-dominated site, not far from here, the manager was willing to participate. The union, the Rail and Maritime Transport Union, was delighted to participate, and their members not only participated, gave their time, hours of interviews and talking about what do you do that's important and what impact does you making a mistake have, and so on. The men involved in that discussion with the pay equity group became real advocates for clerical workers in hospitals, not because they did the same job, but because they did a really important job that was clearly undervalued. And that, I found that fascinating. The men became great champions for it as well. So I'm going to wrap up in a moment because I'm hoping there will be questions. But this is an offensive piece of legislation for a range of reasons. Pay equity is about economic justice, no more and no less. This piece of legislation sends us back 40 years, and education, I've always believed in education as a prime change agent, is urgently needed to bring us back, or bring some people back up to speed about this. And the price, I think, of equity is constant vigilance. And we're in one of those moments now where our vigilance needs to turn to action. I absolutely support the recommendations from the Human Rights Commission to repeal and replace, and I would endorse those comments. At its heart, pay equity runs the risk of reconstructing the economy. That may be a reason for the opposition to it by some people. In the end, I always ask, in whose interests? Whose interests does this serve? And I can say from my 45 years of experience with the issue that it is not women in low-paid occupations who will benefit from this legislation. Thank you.
Thank you. We have Two questions from Jackie Blue and then Dame Marilyn and then Belinda.
Thank you, Marianne.
Thanks,
in the
Jackie.
New Zealand CTU submission, they had a quote from the New Zealand Public Service website that said, pay equity recognises that it is possible for two jobs to look very different but require the same level or similar level of skills, responsibility, experience and effort from employees, and therefore should be paid similarly. And it's still up today, I checked, so that was over a week ago. What do you think that says about the government and the ministers involved in this act, their understanding of pay equity?
I hope I covered that off obliquely in my initial comments. I'm taking to heart the words of the Chair, Madam Chair at the beginning, that said there's nothing defamatory that should be said here. So I'm really grasping for words here.
Right,
it is either willful blindness, either they know and don't want, or they don't know. And right at the moment, I don't know which is the greatest sin.
Right. Thank you. Thank you.
Marilyn and then Belinda.
Marianne, in your written submission, you talked about such understanding and knowledge about the history has not landed with some of our current members of Parliament. When I look at the papers that have been submitted to ministers over the years, let's say since 2015, it seems to me that one might say that the understanding and knowledge has not landed with our bureaucrats, because the same names come up again and again and again, pushing back even against the advisory group. Do you have any reflection on that?
I have always been proud of the public service in New Zealand because it has previously given free and frank advice. I have, as a minister for a nanosecond in my career, been on the end of that free and frank advice, and by God, it's important. And I have been concerned that we are losing the edge of that era of free and frank advice to ministers, because I think some ministers are not aware of how much it rescues them.
Belinda?
I like the succinctness of your words. A comparison of the dissimilar is what we're really looking for. And Dame Sylvia's comment about the sinking lid on pay.
Absolutely.
And I just wondered if you would like to add to that.
I think the sinking lid analogy was a great one. I think it was a great one. I think as soon as you reconstruct those criteria for a successful claim and move the goalposts in the way the goalposts have been shifted in this legislation, you relegate women to comparison with like with like, and that was not ever the purpose of pay equity.
Thank you very much for your submission, and if you could circulate any oral notes, that would be appreciated. Mahi.
Certainly. Thank you very much. And Marilyn, could you possibly do another reprint of Counting for Nothing? You did one in 1999. There's only 123 copies needed in this reprint.
We will call on our next submitter, Coalition for Equal Value, Equal Pay. Welcome to the People's Select Committee. Please take your submission as read, and there will be questions to follow. No mai haramai.
Thank you. We are three stalwarts of CEVEP, long time stalwarts. I go back more than the 40 years that was referred to. It's 53 years since the Equal Pay Act, and this would take us back to, well, when that was misinterpreted as referring only to equal pay for the same work. Thank heavens we started interpreting it correctly as equal pay for work of equal value, which I prefer to pay equity because it's clear, it's clearer. My name's Prue Hyman. I'm a retired long retired associate professor of economics and gender and women's studies at Vic, and author of 2 books on feminist economics. Pay equity, equal pay for work of equal value is an important component of those. You can, as well as reading Marilyn's book, read my couple of books. With me is Linda Hill, who is author of a very learned PhD thesis on feminism and unionism in New Zealand, and is a long stalwart worker on pay equity, and Sibylle Locke, who is a feminist historian, I guess, and labour historian, which describes her. And behind us is Rachel Brown, who is an absolute stalwart for organising CEVEP, getting us in order all the time. CEVEP is a tireless lobby group for equal pay for work of equal value for almost 40 years. We have the next, right. That details, I won't go through them, some of the things it's been involved with, all the various stages of change, and Labour, well, National, one has to admit, did pass the Equal Pay Act. One has to give them that small amount of credit, while they have had it all withdrawn now. And Labour have mostly made the advances, and National withdrawn them ever since. But Labour too have been blameworthy. They've been scared of the costs, which the costs are there. One has to recognise them. They're the cost of women being exploited right through the labour force, and particularly low-paid women, Māori women and Pacific Island women, whose gender pay gap is even worse than for Pākehā. Linda's done the grunt work of calculating the extent of the gender pay gap and the wider ethnicity gaps, and putting it on our website over the years. It's still up there, you can still find it on the website, and she drafted this submission. We're totally scandalised by what the government has done in total secrecy, trying to abolish the whole concept underlying equal pay for work of equal value, essentially, because it reveals the extent of underpayment in female-dominated areas of work, and would cost a lot to remedy. The whole point of equal pay for work of equal value is to compare male and female-dominated work on skills, effort, responsibilities and working conditions in great detail. I hardly heard those 4 categories being referred to in the debates initially on this. That's the whole point of this, and that's why it has to be different work, which is what they're trying to abolish. Because it's female-dominated work and male-dominated work. But when you go down into the detailed skills and responsibilities of caring work, for example, you can't compare it with other caring work because all caring work is undervalued. So it would take back pay equity 53 years to the Equal Pay Act 72, which was initially wrongly interpreted to be covering only identical work. Finally, from me, before I shut up and have taken longer than I promised Linda I would, I thought I was up in the whole area when involved in the Christine Bartlett carers case. But I remember being utterly amazed when I read the list of requirements of the job she did. They were incredibly impressive, and much more than I thought caring work involved. And you could only compare them with different male work. I reckon if you compared them with MPs of the government parties, if they tried to do it for a week, they'd soon realise the job was probably worth more than they do, their job. So now I'll pass on to Linda.
Thank you. I want to focus on what we feel is the core, most important change they made, which was to the selection of comparators. So the Equal Pay Act has been continuous legislation since 1972, and I think that's important. It's been amended, but it's been there in compliance, as other people have discussed, with ILO 100 and the CEDAW Convention, which both require equal pay for work of equal value. And this government confirms its support for pay equity, and yet it has limited the scope of male comparators. It seems to lack understanding that the structural gender and race discrimination in the labour market by occupation is a feature of the whole labour market. And the more you disaggregate down from one sector, say government, to health, and then you get down to caregivers, the more you disaggregate, the more strong is the occupational segregation and the undervaluation. So whole sectors and whole industries are designated female and underpaid for their skills and responsibilities experience compared to male-dominated jobs, sectors and industries. And this is very well known. There was a very good book in 1990 by the Council on the Advisory... NACU, National Advisory Council Beyond Barriers, about occupational segregation, in the New Zealand labour market, about vertical segregation, which is the glass ceiling, about that, and so very well known. As the last speaker was saying, how come they've missed it? I don't know. It does seem like deliberate unwillingness. What I want to do is to get you to look at some of the texts. The new hierarchy for the selection of male comparators in the rewritten S13ZE is that you must select comparators that are most closely related to the employer. If the employer employs one or more comparators, the party must select one or more of those comparators. If not, one or more comparators by one or more similar employers. If neither, one or more comparators from one or more employers within the same industry or sector. And no opportunity to compare widely across the labour market, to look at the labour market actually as it actually is constructed by and shaped by devaluation of who you are, not what you're doing. This is contrary to the court's rulings in Bartlett and Bartlett versus Terra Nova. CEVEP was invited to be I've never found out actually how we came to be invited, but we didn't say no, to be a friend of the court. And some of our members, like Elizabeth Orr, were around from the Government Services Act, 1960. And were able to provide material about, you were on the advisory committee that was in advance of the 1990 Act. 1990. We've had CEVEP members all the way through there. We were invited to be a friend of the court, and we were able to provide a lot of historic material. Steph Dryberg was our barrister at the time, pro bono, what I want you to look at is what the Employment Court said about the selection of comparators. They were looking at the meaning of the Act, the parliamentary purposes in the run-up to the Act, what it was about, what the criteria of the Act, which is the skills, responsibility, etc., which are now written into the 2020 Act in a dozen different places. And then they were focusing on the selection of male comparators in order to address the different work that men and women did. So the Employment Court said, in order to select appropriate male comparators, the comparator needs to be identified that is free from any gender bias affecting the rate of pay if the purpose of the Act is to be achieved. If a comparator that is unaffected by gender discrimination cannot be found within the workplace or the sector, it may be necessary to look more broadly to jobs to which a similar value can be attributed using gender-neutral criteria. So the court got it, and the appeal court, which said that the Employment Court's judgment had been a strong judgment, said the Act is not limited to providing equal pay for the same or similar work. So those quotes were in our submission, and then I had another look at it and found, of course, more that are closer to what the government is trying to say and were rejected by the court. So a court judgment, the whole thing that they wrote is the judgment, right? There's not like a thingy and then this is the conclusion and this is the recommendations. The whole thing is the judgment. But at the end of the Employment Court's judgment, it did return to some rather convoluted lawyerly questions that Terra Nova's lawyers had asked. And got the next one. Right. So, in considering that issue, is the authority or court entitled to have regard to what is paid to males in other industries? And the answer of the Employment Court is they may be if those inquiries of other employees of the same employer, other employees in the same or similar enterprise or industry would be an inappropriate comparator group. And we've just given quotes about what an inappropriate comparator group would be. Next one is, does an employment agreement provide for equal pay in the terms of the Act if the relevant employer pays its female employees as compared to its male employees for the same work where they have the same substantial skills responsibilities? And the answer was, not if the rate of remuneration is affected by gender discrimination. And as the previous discussion of court said, that is if they're in the same sector, which may be undervalued because it's a predominantly female sector. So it seems to me that what they have done is directly against the case law of the 1972 Act. It's continuous legislation. It's not as if they're fiddling around with a bit of one clause on selection, affects in any way the court judgment on the intent and purpose and the principles of selecting male comparators. So I think this needs to be challenged. But the problem is that, like, CEVEP knew for years. I mean, it was Martha Coleman's opinion, and she was one of the people who set up the CEVEP in 1986, that a case ought to be taken. And the Bartlett case, it took all those years and no more political possibilities before the unions were able to. CEVEP never had the resources. I don't know how people are talking about all this litigation that's going to happen. We've never been able to do it in the past. Politics has been the only way we've succeeded, and then slipped back, and then succeeded, and then slipped back. Well, we're slipping back at the moment. So I think that the fact that what they're doing is actually a contradiction of the case law and the ruling of this important case, the Bartlett case, needs to be the basis of challenge. So.
Thank you for
I'm
your...
getting steamed up here.
Dame Marilyn?
Yes, it's a slightly different question, but I think it's really important to get it on the record. So Prue as an academic and Linda as a PhD graduate. We've had lots of flippant comments about the comparators, but what I'm interested in is how familiar you are with the process that has actually gone through to arrive at a settlement. Let's take the social workers, for example. And academically, how might you describe the calibre of that process?
Well, I think it's now extremely detailed and extremely... but also, someone was telling us about their caregivers negotiation a couple of weeks ago, that it's based on detailed interviews, that the detail that people go into to examine the kind of work and discuss it, and also at each side, at each stage, this is being discussed between the employers and the claimants, right? It seems like all the way through. The tools that are being used now are so much more in advance of what they used to be, I mean, they were developed by the Pay and Employment Equity Office in the 2004-2008 period, and tools for reviewing departments and identifying where there might be an arguable case, and then the job evaluation, and then the State Services Commission they've been in there doing this. It's an extremely slow process, but then so was the law case. That took 4 years as well. So everything we try and do seems to take forever.
I used to advise my PhD students, we were looking for sophisticated rigour. Would that be a fair description of the process, do you think?
I would certainly say so. But we are a policy group. Members among us are doing that kind of work now. People go in and out of CEVEP depending on their job availability and who their employer is at the time. But yeah,
I could remind the committee that employers have used job evaluation, Hay schemes, Price Waterhouse, etc., since time immemorial. The only thing is they were incredibly gender biased in the factors they used. We have, grown up since then. We did an equitable job evaluation scheme. I can't remember when, in the 90s anyway, and it's got more and more sophisticated. It's absolutely appropriate to compare whatever it is, a fisherman something, I can't remember the ones that
fisheries
they quoted as being an inappropriate.
Social worker with an air traffic control person like my brother.
It may very well be totally appropriate when you break down the detail to go right into the skills, efforts and responsibilities that
there's
involved.
A lot of government work has gone into this, not just claimants' work.
We have one final question from Steve Chadwick.
From you would help our committee. Do you want repeal of the Act, or do you want amendment to the comparators review?
No. Repeal of the changes to the legislation that have just been made.
Yeah.
And I hope we can get political commitment to that. But God knows what they'll do between now and the next election.
I think repeal is better than
But the words you used suggested repeal of the Act. No, it's continuous legislation from 1972.
Yeah.
And there's still room for improvement from what there was in 2020, but certainly get rid of those changes and go back to the process that is being used now successfully.
Thank you.
And think about ways it can be used within the private sector, because it doesn't work very well outside the state sector.
Thank you very much. Thank you. Kia ora. We'll call on our next submitters for Zonta. Welcome. Please take your submission as read, and we will have some time for questions afterwards.
Awesome. Kia ora koutou, ngā mahina nui kia koutou I tēnei wā, ko Belinda Himiona tukuingoa, ko Ngāti Apa, ko Ngāti Hauati ngā iwi, engari e tapuaki au ki kaikohi I tai tukarau. So, kia ora, nau mai. And I'll allow Jen, I'm with Jen McKinlay-Birkin, also from Zonta. So we're representing the Zonta Club of Wellington today, and I just want to start with an enormous thank you for this opportunity to join this hearing today and to speak about the significant kaupapa for women of Aotearoa. It is really humbling to be in this room, and I've loved the friendly sharing and learning that we've been doing together already this morning. I would apologise for the weather, but it feels appropriate that it is a frosty Wellington day for this hearing, because while we've brought the spirit, this is something we all wish we weren't having to talk on today, no doubt. The Zonta Club of Wellington is part of an international network of over 1,000 clubs worldwide, and we also have general consultative status at the United Nations. Our mission is advancing gender equality and empowering women through service and advocacy, and essentially we aim to build a better world for women and girls. I bring Zonta's proud whakapapa with me as I present today, but I also bring our proud Aotearoa heritage, where we have fought for centuries to stand up for the rights of women.
I'd like to start my kōrero today by stating that the Zonta Club of Wellington opposes the Equal Pay Amendment Act 2025. We are extremely concerned that the recent amendments to the Equal Pay Act will undermine gender equality and goes against women's rights to receive equal pay for equal work. In terms of our core concerns, I'd like to start by saying that it's excluded the voice of women and girls in affected communities, and the lack of consultation and the misuse of urgency is extremely troubling. This law change was made without any opportunity for public discussion, and most importantly, without any discussion with women and girls and those who had claims underway. This has taken away our right to have our experiences, our perspectives, and our aspirations on the record. We're also concerned that the changes undermine progress made under the 2020 Act, which had really broad support. It was a wonderful day seeing that passed in Parliament. It provided female-dominated workforces with an accessible pathway to pay equity, and believe this has been damaged in the latest amendments. And finally, the amendment discontinues, as we know, 33 active claims impacting over 150,000 women, including those for teachers, nurses, care workers, professions all dominated by women. Many of these halted claims have been under development for years, and I've heard others speak passionately about this before me. Make no mistake, these changes create a bleaker future for the girls of Aotearoa who are wanting to make a career in education, care and health areas as adults. They will enter the workforce without hope of being equal to their counterparts. I want to speak further on the disproportionate impact of women also. There are several concerning aspects in the amendment. The threshold, as you'll know, that requires 70% of the workforce to be female for 10 years. This will really exclude many claimants' accessibility to the process. Obviously, the removal of back pay provisions denies justice for historic undervaluation, and the 10-year moratorium on resubmitting claims will just recreate the inequities that we needed to expel by taking the claim in the first place. In terms of economic and social consequences, we know that pay equity boosts household income, savings, national economic resilience, and the future and wealth creation of women. Māori and Pacific women are particularly impacted. They're disproportionately overrepresented in these workforces where pay inequity exists. And with worsening pay equity, there will be social and economic consequences. The changes also impact on our international obligations and put us on the wrong side of history on this matter in many regards. New Zealand is a signatory, as we know, to CEDAW and the ILO Convention 100, all about wanting us to not discriminate against women having equal pay for equal work. And this Act moves us many steps from compliance with these obligations. We should be alongside countries like Iceland, Sweden and Quebec, Europe, UK, who have shown some wonderful changes. And we used to be in that leader pack, and now we have slipped behind, sadly. I also want to stress that equal pay is about values and rights. It is not just a policy conversation. It's about dignity, fairness, our national values, and above all, we strongly state that this change will have real-life consequences for working women in Aotearoa. Professor Gail Pacheco states that significant savings to the government will come from the pockets of these women. We want to ask, do we value women's work equally? If so, our laws must reflect this. This law change means we are losing ground from the 2020 legislation, and we're stepping backwards regarding rights for women in Aotearoa. We come here today to recommend that there is a repeal of the 2025 Amendment Act and we reinstate the 2020 framework, and we commit to regular public reporting on pay equity progress as a nation. And in closing, I want to emphasise that legislative changes of this magnitude affecting women must always include our voices. As we can see today, we can share, learn, constructively discuss, debate and uplift each other towards a better future. And Zonta stands ready to support a fairer, more inclusive pathway forward. So kia ora koutou.
Thank you very much. Questions? Any questions? It appears that you are very... Oh,
yeah, I would just, one of the parts that particularly struck me was when you write, this is more than a policy issue, it's a question of national values. And would you like to expand on that?
Yeah, I think we can talk in the philosophical, which is also important, but our values have always been egalitarian. We do believe in fairness, justice, equity. I think this is the heart of our proud history, and we've also had such a long history of making positive change for women and getting over the line together, and I really feel like this undermines those core values.
Sorry?
Thank you very much for the submission. I'm sorry I missed dinner last night.
Yeah.
I just wondered, I have this impression that Zonta may move in circles that some of us don't move in, like in all parts of society. Do you have a sense that women in upside well-off society actually would support what this government's done on pay equity, like more women from a more conservative or middle or upper class background?
Yeah, I mean, yeah, and I think it's a great question. I think this is an issue we unite behind. Like, I've heard distress from many quarters. Whether or not I agree, there's a lot of misunderstanding about what pay equity is versus other things like pay parity, etc., and how you show that. But I think the social justice aspect of this resonates with all classes, and I think it is one where and male allies as well, so this has also been a cross-gender conversation that we've been hearing around Aotearoa, so I think this is one that can really unite us, and as it should.
Kia ora.
Yeah.
Kia ora. One more quick one from Belinda.
Separate from the repeal of the last legislation, are there any other measures that you would like to see change to the 2020 Act?
I think the greater focus on reporting and would be fantastic going forward. I've had some professional connection with a process that was quite long. So I think it was amazing to have a practical process in the 2020 and a good framework. It did take some time, and I think we would like to see that streamlined if the Act was repealed and we went back to the 2020 framework. I think you can always learn from these acts, and you put it in, you are ambitious about the change, and then you consider and think and reflect and you review and you discuss. And I think part of the distress here is it may not have been perfect, but we didn't get the chance to learn from what was put in 2020, and I think that's really fundamental to making good change going forward.
Thank you very much.
Kia ora.
Kia mihi kia koutou. We'd like to call on the next submitter, which is Tony Mcomes. No mai hara mai. Please take your submission as read, and there will be questions to follow.
Tēnā koutou katoa. It's wonderful to see Elizabeth Mcomes' picture hanging above us. I'm hoping to, in some way, provide her with a voice. Kia ora. My name is Tony Mcomes, and I'm here not just as a New Zealander who believes in fairness, but as the great-grandson of Elizabeth Mcomes, Aotearoa's first woman elected to Parliament. In her maiden speech way back in 1933, she said, "I wish to work for the women and children of this country, and I hope to see the day when women will receive equal pay for equal work." And here we are, 2025. If she were here today, she would be appalled. My own daughter, also proudly named Elizabeth Mcomes, is an early childhood teacher. I want her and my granddaughters to live in a New Zealand where they are treated fairly and equally, not forced to fight the same battles over and over again. As you know, pay equity is not complete. Women in many sectors are still paid far less for work of equal value. These amendments don't just freeze progress, they actually push us backwards and try to lock the door behind us. The changes passed under urgency are not improvements, they are betrayals. Calculated, mean-spirited rollbacks of hard-won progress. It is not reform to raise the threshold for a female-dominated workforce to 70% and demand it holds for 10 consecutive years. It is not reform to force the burden of historical proof onto those already underpaid. It is not reform to ban cross-sector comparisons as if injustice respects tidy org charts. This is not simplification, this is sabotage. These changes do not serve workers, not nurses, not early childhood teachers, and not care workers. They serve the privileged, they serve the landlords, the lobbyists, and those clinging to power with cold fingers and colder hearts. This is a government that can spend weeks debating road cones, but will gut women's pay equity protections in a single sitting day. I'm old enough to remember David Longy. He said of uranium, you can detect its presence by the stench on the breath. I smell the stench of privilege and willful ignorance. It reeks of arrogance, exploitation, and the contempt of those who think they will never be held to account. These changes are not about fairness, they're not about sustainability, they're about saving money at the expense of those already underpaid, turning women's wages into a political piggy bank. This is not reform, this is theft from the future. They are sexist, cowardly, and they insult every woman who ever fought for equality. If those backing them had any sense of history or any sense of honour, their mothers, grandmothers and daughters would be totally ashamed. Ashamed of the silence, ashamed of the cowardice, ashamed that those that they raised who would inherit this progress would choose to destroy it. We are being dragged backwards by those who benefit from the old boys club, dressed in suits, erasing hard-won rights and calling it reform. I oppose these amendments entirely. They represent a shameful low in our legislative history. If Elizabeth Mcomes were here, she would rise with righteous rage and ask, how dare you? How dare you erase progress with the stroke of a pen? How dare you undo a century of struggle in a single vote? How dare you silence the voices of working women and call it reform? Finally, I say this is not your history to erase. It is our future to fight for, our progress to protect, and our equality to win. Thank you.
Thank you. Thank you very much, and I will take questions from around the table. Stevie?
What decisions we say, and your grandmother would be so proud of you. And can we just thank you for bringing men's voices and young men's voices to the table to share the conversation that we need to have nationally. I don't have a question, you said it all.
Thank you. And I did grow up with equality, and it just seems absurd that we're here today having to fight these battles, 92 years later. Yeah.
You made the comment in your submission about the intergenerational impact of decisions like this, referencing your daughter and the area that she's working in. Can you perhaps forecast out what you see as the critical implications on the next generation of women?
It honestly feels oppressive, and for me, I think fairness is something I've been brought up with, I come to expect, and to see this oppression isn't looking backwards, it's actually looking at today, unbelievably. It's looking at the future. I look at my little granddaughters and I think, goodness me, why are they putting up with this? They really shouldn't have to. It shouldn't be a fight that we're having. It should be a fairness and equality, that we all stand the same, arms linked, and sing the same tune.
Any other questions? Lynn?
Thank you. I think you did very well. Thank you. Just in terms of your great-grandmother and the proud history we do have, or we've had over the years, how do you think that this move is going to make our little country look internationally?
I like to think that we stand on the shoulders of giants, and Elizabeth Mcomes is something of a figurehead, and her sisters worked tirelessly as well to raise equality. And so, you'd like to think that our little flag is actually a big banner, and that we do stand proudly, and that we are bigger than the country in which we stand. And we should be standing together, and we should be showing the world how we do it right.
Dame Marilyn? Yes.
Yeah. Your men friends. No, but I'm really interested in you know, we anticipate what women's voices are going to be saying. I'm in my 70s and I have never been approached by so many men before about an issue. So I would love to know, you know, what it feels like for you out there in the company of men.
It is really shameful, and you know there is a real element of guilt. You know, when I say that there is a huge amount of cowardice from this current government, it is because we should be standing up and standing together and standing for fairness and equality. But it feels like the opposite, that it's about greed, it's about robbing literally the money from one hand to pay for the greedy landlords and the lobbyists and those with the big voices and deep pockets that can actually buy their way into power, and that's wrong.
Final question from the end, Azil.
I did want to just briefly ask a question because I've just wanted to say how much Elizabeth Mcomes is honoured in Ōritenga, Christchurch, where I come from, because of the seat being the Littleton seat as the first seat held by a woman in New Zealand. So I just wanted to acknowledge that, but also to ask you a question, which is, because we're holding this People's Select Committee, first time ever been done, because there was no Select Committee, there was no opportunity to give voice to how people would react to the changes if it had been introduced as a bill that was referred to a select committee. Would you have made a submission if it had gone to a select committee, and what would you have asked for it to be done, you know, if you'd been given that opportunity?
It's a really good question, and I am a proud Cantabrian as well, and I would like to think due process would actually come up with the right answers, and the real problem here is that due process hasn't been followed, and so we're having to speak louder and fight harder for what is justice.
Thank you very much. Ngā mihi kia koutou.
Thank you.
Can I call on our next submitters, NZEI, PPTA teachers claim. Kia ora. No mai hara mai. No mai raro mai, tēnā koutou katoa. Please take your submissions as read. Feel free to circulate any information afterwards, and there will be questions to follow.
Kia ora rā koutou, NZEM committee. Korepeka Lascelles tōku ingoa, he ahu mai rā hau I nā pai mauna o Ngāi Hoi o Ngāti Awa. Engari ko hau te manukura o NZEM te rūro I tēnei wā. So nā mihi rā kia koutou. Can I just introduce to you, on my right is Mel Burgess. She's a kindergarten teacher. And to her right, far right, a couple right over, is Kalisha Segeta, who is a primary school teacher. And I'm joined on my left by Stephanie Mills, the National Secretary of NZEI Te Reuroa. And also we have on the table, Jo might like to introduce herself and later on in the piece. You will do that now? Yeah.
Tēnā koutou katoa, e whānau mai au te papaioia, engari no kotirana me airani o kutipuna, kei te noho au e nai nei ki te whanganui ātara, ko Jo Brunskill tōku ingoa, tēnā koutou katoa. Kia ora everyone, I'm Jo Brunskill, an advisory officer from PPCA Te Wehingarua, here to speak on behalf of the secondary and area school teachers and principals whose ability to progress a claim has been cancelled, removed from them, and who have no further ability to raise a new claim. I'd also like to introduce our support team. We have a secondary teacher member, Stephanie O'Brien, who you'll hear from shortly. And behind us we have Kirsty Farrant, our General Secretary, Fran Renton, Deputy General Secretary Policy, and Adele Toogood, Deputy General Secretary Membership.
Kia ora. So kia ora koutou. While I might be the president of NZEI,
currently I'm also an educator and have been for just over 40 years as a primary school teacher, a secondary school teacher, and a principal of late. We are here likewise to represent the early childhood primary with PPTA, our area school teachers and principals whose claims were cancelled. Later in your hearing, we will return and speak again on other NZDI Te Reo cancelled claims and reviews, including teacher aides, kaiarahi te reo, librarians, administrators and science technicians. I'd also like to say thank you for making available this opportunity to speak where this government wanted to silence this particular kaupapa, not just to these around the table, but to the whole of the country. So thank you very much for the opportunity to speak today. You've received our written submission from PPTA Te Wehi Ngā Rua and NZDI Te Rua, and we're really, really pleased to be here. We appreciate the mahi that you are undertaking, but also here that our members want to speak about today. We want to give the opportunity first off for our teachers who are here to share the way that the 2025 amendments have impacted them. Kia koe mea.
Kia ora, I also want to give thanks for the opportunity to speak when the government wouldn't let us. I said in my written submission, I described how it took me 4 years to get my qualification, and I had 2 young children and a mortgage to pay off at the time. It was a really hard slog, but I was driven to succeed, and I was excited to start my career in a worthy profession where I could continue to develop professionally. When I left university, I heard of an IT graduate that was going to have a starting salary of $20,000 more than me. And that wage gap has had long-term consequences for my family, my loan repayments, our lifestyle choices and our retirement savings. And I often think about what his KiwiSaver might look like next to mine all these years later. ECE is a demanding job emotionally, physically and mentally. But I love it. I give the best of myself to other families, and I go home without much left in the tank or the pocket. But I really believe in the value of my work. The Christine Bartlett pay equity case opened my eyes to the injustice of the pay discrepancy with traditionally women's work sectors. And that's why I started to get involved in NZDI's pay equity case when it began in 2017. We're 98% women in my sector, and despite our crucial role, we're undervalued because of the element of care in our work and of the age group that we teach. The mix of private and not-for-profit employers further suppresses our wage, and we have never achieved across the board pay parity with other teachers or even amongst ourselves because of this. So in my pay equity advocacy, I reassured my colleagues that although the pay equity process was complex and slow, it was the most secure mechanism to lift our pay. I thought that because of the legal precedents and the cross-party support and the joint employer claimant process, it seemed to give an assurance that any wins we did make would be protected from whims of changing governments. But I didn't anticipate the ruthlessness of this government. Our claim started 8 years ago, and when it was merged with the wider education sector in 2020, we had to start again. So we'd already done a lot of work. We'd already done the interviews about sizing up our job roles. But still, we started again, and we've continuously rallied for support and awareness and restated our qualifications, skills, effort, experience, stress factors and working conditions. Low-paid women, working women like me, helped fund this with our union subscriptions. And progress was slow, but it was real, and now all that mahi is gone, and without warning or consultation or mandate. It's a shameful waste of time and money. And Brooke Van Velden knew that this change would breach human rights, but she went ahead anyway, because she deemed it a lower priority than protecting employers, of which the government is one, the main one. And now we've got to face starting for a third time, and this time we've got nearly impossible barriers to overcome. So I'm just really sort of angry about it. I'm really angry about the way she minimised the comparator selection process and that trite soundbite that was already mentioned with the air traffic controllers. It really got my goat because I think it did the whole thing a disservice and it was intentionally diminishing. So if any process needs more scrutiny, it's the government's. These changes were a stealth attack on our democratic rights, cutting out our voice completely, and that only happens when you want to silence dissent. Thanks for your time.
Thank you, Kalisha. Kia ora, ko Kalisha taku ingoa. He kaiako he te kura takawainga o Hurukiwi. I'm a teacher at Newlands Intermediate School in Wellington, which is tough graft. And I sit here today submitting this claim not just for myself, but on behalf of teachers from across Aotearoa who have been directly affected by the under-evaluation of work that's been done in the education sector over my entire life, basically. Many of us have experienced the personal and professional impacts of pay inequity. Many of us have struggled to support our own families on salaries that didn't reflect our qualifications or our responsibilities. We've seen passionate colleagues leave the profession because the remuneration couldn't match the demands that are put upon us every single day. The recent move by the government to undermine us further has been a real blow to all of us and has actually left us feeling less important than we did before. The current pay equity claim process is an essential step towards correcting these injustices. But for this process to be meaningful, it doesn't just need to close the pay gap. It needs to restore mana to our profession. It needs to acknowledge the deeply gendered assumptions that have shaped public perception and valuation of teachers' work. It must ensure that future teachers never again are asked to accept less just because they chose to pursue a career in care and connection. Over the past 9 years of my career, I've had the privilege of working with countless tamariki and rangatahi that are incredible. And I've been lucky enough to see the impact that meaningful, consistent and compassionate teaching can have on a young person's life. I've also been lucky enough to see how some of my students, too quickly, have grown into really well-rounded, amazing adults. And it's incredible to know that they still reach back to us to tell us how they're going. Even 9 years later, hey, I just finished uni. They still care about that connection they have with us. When they see us in the supermarkets, they're excited to see us and tell us how they went. And I carry immense pride when I tell people what I do, because I feel like I make an impact every minute of every day. I would really like future teachers to feel that pride. I want people to stand up and say, I'm an educator, and I'm proud of that. But at the moment, in our beginning teachers that are coming through, I don't see that. I see teachers looking for other opportunities. I see teachers looking overseas. I see teachers going, I'd be paid more to do considerably less in another profession. And what concerns me is that who suffers? Our children. Our children, our young people suffer. We need to ensure that our profession remains sustainable and it remains respected. If we continue to lose teachers to other professions and other countries due to poor pay, the impact on our country is immeasurable. Teaching is the profession that is foundational to all others. This is where it starts. And if we want to have a successful country, we need to have successful young people coming through our kura. We need to have people that are confident, passionate, and have human connections that are meaningful to them, who want to continue to build that. So I urge the committee to recognise that this claim is not simply about fairness in numbers. It's about equity and how society views and values our profession. A profession, as I said, that's foundational to every other. And if I think about myself, I'm 4 months pregnant. I haven't taken any time off work because who will be there if I'm not? So you think of all the things that we sacrifice, you think of all the things that we do, and we do it because, not because we have to, but because we want to, because we have those same 33 little eyes looking at us every day. So, yeah, thank you. That's
Tēnā koutou katoa, ko Stephanie O'Brien toku ingoa. He kaia ko mahi toia hau ki te kāreti tamatane o te whanganuiatara. So teaching is not just instruction. It's hours of planning to make lessons accessible for every one of the 147 students I teach each week. It's liaising with whānau and colleagues, identifying learning barriers, tracking attendance, providing pastoral care, and creating inclusive resources. At night, after I put my 11-month-old to bed, I'm marking, I'm writing feedback, I'm tweaking lesson plans. Sometimes I'm up late on the couch, surrounded by student work. It's not just the classroom. It's emailing parents at 9 p.m, running lunchtime catch-ups, clubs, after-school scholarship sessions. It's noticing who's falling asleep in tutor time, who hasn't eaten, who's struggling, and showing up for them. That's why the cancellation of the teachers' pay equity claim makes me feel deeply frustrated and disheartened. It tells women that our time, our expertise, and our commitment aren't valued. I love my job, but we all know that teachers are undervalued. We have a teacher shortage and a crisis in retention. We can't fix that without valuing the ones that we already have here. We can't fix it without valuing teachers. To value teachers, we need to ensure that they are being paid for all their work. Work that is free from sex-based discrimination, work that is valued. Thank you.
Thank you for your patience with our musical chairs situation over here. So just to outline the claim briefly, as you've seen in the written submissions, but also for those who are tuning in, the teachers' pay equity claim was the largest pay equity claim to date, covering over 95,000 teachers and school leaders, so ECE, primary, area school, secondary, teachers, leaders, principals, everyone. It was a multi-employer claim, which added a level of complexity that hadn't necessarily been seen to that extent. There were Ministry of Education as a main employer, but also around 520 private and community-based early childhood employers. It was raised in terms of the teachers' claim, as you've mentioned, in late 2020 and consolidated between the unions, and we have worked together well and strongly for a large number of years now to try and get this across the line. We had completed over 300 interviews with claimants. We had done the same for the supervisors of those claimants. We had done around 40 interviews with potential comparators. And in terms of a rough time frame, we were expecting to start bargaining in 2026. As we've both outlined in our written submissions, the government had been making changes behind the scenes to attempt to rein in settlement costs. We saw it through pay equity resets and different frameworks that were brought in. This had led to increased difficulties for the union parties in particular around comparator selection, with the employer parties pushing for lower paid and often female-dominated comparators. There was also a lack of commitment to government funding for the ECE sector settlement, and that has also led to delays as the parties sought a commitment to that funding. This may have also led to an increased pressure from early childhood employers to try and reduce the cost of any settlement because they didn't have that support to cover it.
And just to add briefly to that, since we wrote our submissions, obviously a large number of OIA documents have been released, including cabinet papers, and under Project 10, there was clearly a method to conceal the amendment bill in its prior to it coming through. One of the major issues, obviously, is the comparator hierarchy. As we understand it, the papers show that originally external comparators were going to be included, but they came right out in the final version of the legislation. And we believe that clearly that was a move to prevent teachers from achieving a pay equity settlement under the new system. I think if you wanted to go through the legislation with a red pen to cross out all the bits that would let teachers win pay equity, this is what you would have done. Extinguishing the teacher pay equity claim appears to be a key reason that all these changes were made under urgency, in secret with no scrutiny,
to get the costs of this off the government's books in time for Budget 2025.
So in summary, the Equal Pay Amendment Act 2025 is a huge attack on public education. Our members have invested significant time and resources into the teachers' pay equity claim. We look forward to presenting individually to talk more specifically about the issues in our parts of the sector and the impacts. But thank you for this opportunity, and we're happy to take any questions you might have.
Tēnā koutou, and thank you for the powerful impact of your submissions to the committee. We hear you, and we hear the time and effort that has been put into a profession that it is evident that you love and that our kids benefit from. This is the People's Select Committee, so I am going to ask the forbearance of the next submitting group if we could provide at least a brief amount of time for some questions from the Select Committee. It will not affect your time, will extend on the other end if that's okay. So I'm looking at the New Zealand Nurses Organisation, PSA and ETU, if that is agreeable to you. I see heads nodding, so I will take questions from around the Select Committee table at this time. Thank you. We'll go with Ria, and then Belinda, and then Jackie. And then...
Kia ora. I think I can say quite clearly that your submission that you provided to us has been immense in the mana that you've shared, and having you each speak today about your experiences within the education sector. So listening and knowing that your claims have been not once but twice chucked out, and now you're faced with what you're going through right now. What has been not only the emotional cost, but what has been the financial cost to have to go through this?
I mean, the financial cost has been, I would actually like to know the financial cost, but as I understand it, they haven't gone into that when they've been doing this stuff. They haven't actually revealed how much it's going to cost overall. But I can talk about the cost to me personally. It just feels like such a waste of sort of volunteered hours, such a waste of my union's time and resources to have gotten us through so far. And the reason it was slow is because it was so precise, and to have that just kind of tossed out is really devastating. It really is.
I would say relievers costs. So I was involved in multiple interviews. They needed a reliever for my class while I was not there. Equally, there's other people involved in each interview. There's 3 or 4 people walking into each one. So you think the financial cost to your kura and union that has to pick that up on the other side that now is wasted. So.
Thank you. Belinda?
I just want to focus on the amount of time, and I guess the complexity of your combined claim accounts for that long time. But I just wonder whether there could have been or should be a better way to do it that doesn't take that length of time. How could that time be sort of shortened or without losing the effectiveness?
I think on the ECE side, there was no culture of employers working together, so that took a long time for them to come together as a group of peak bodies. I think the other factor is that the government is both the funder and the employer. So it has no incentive to settle, to get through this process fast. And unfortunately, I think both Labour and National refused to really put their money where their mouth is in terms of the ECE sector in particular, and making that commitment to keep employers in the game and keep the pace on. So that would be one of the factors, that the loss of what was known as the funded sector framework really set us back even further. But even prior to that, Labour was reluctant to commit the funding. And I would say that's also because they haven't done a close look at what the benefits of pay equity are in our sector. You know, we asked Treasury recently in a meeting about that, and they said, oh no, we haven't done that. Maybe MB did, but I don't think they did. But I'll pass to Jo.
From a more technical sense, in terms of the interview process itself, I think what would have been really helpful was to have government support for and resourcing for the comparator interviews. Each time that we went looking for a potential new comparator, we had to reach out to, you know, the heads of those associations, try and find someone who would be willing to allow their employees voluntarily provide 90 minutes plus of their time, it's a really hard ask. So if the government was willing to, actually wanted to see this process through to the end, they would help provide public sector workers and resource that time so that it wasn't at a loss. We weren't having to go and knock on the door of every association trying to find someone who'd be willing to help us.
I'll go for one more question from Jackie and then you can lead off on the next submitter.
Thank you for your submission. I was quite shocked to read that with the 2025 amendments cancelling your claim, and those groups who have had already a settled claim, there are now pay imbalances, and that's causing turmoil and destabilising. Not only are you being attacked from the outside, you're also having turmoil inside. So enlarging on that or just some comments would be great. Thank you.
Yeah, so that was some feedback that came through really strongly from the Secondary Principals Council from PPTA. They're facing situations where their employees know what each other are paid. They're on pay scales that are visible, and some of the people who are now in leadership responsibilities are being paid less than some of, for example, ministry therapists. We've got some imbalance between a graduate teacher and the teacher aide who might be working in their class. It leads to a really difficult situation in terms of individual tensions that principals are having to manage across all of the kura in Aotearoa now, but it also leads to a really difficult position for recruitment of teachers. Because if you can see that you'd be paid almost as much or more, why would you go away and do 4 years of study when you could just walk into that job? Or if you look across the sector at nurses and police, other roles that are public sector facing, when the pay is almost 15,000 more on your first day, that's disgraceful. How can we improve this teacher shortage crisis?
Thank you very much. Feel free to circulate any supplementary information, and we will, if it's okay, make some supplementary requests for information as well. Thank you. Marian. Our next submitters are the NZNO, PSA and Air 2, Care and Support Workers Claim. Kia ora. Nau mai haere mai, I raro I te manaakitanga o te wā. Welcome. Please take your submissions as read. Thank you for allowing the previous submitters to have a little bit more extra time so that questions could be asked. It won't affect your time. Mihi ana kia koutou.
Koutou. We're going to introduce ourselves and then we're going to have different speakers. Nō reira, tēnā koutou katoa, ko Rachel McIntosh tōku ingoa, ko Hekitaria Motu o E2. Tōku Mahi. My name's Rachel McIntosh. I'm the National Secretary of E2.
Kia ora tātou. Ko Muriel Tūnoho ahau he uri ahau o Raukau ki Uta ko Raukau ki Tai. I'm a worker, a life member and co-president for E2. Kia ora.
Kia ora koutou, ko Melissa Willie tuku ngō. My name's Melissa Willie. I'm from the Public Service Association, Te Pikinga Here Tikanga Mahi. I'm an Assistant Secretary there. I was also the lead for the unions in this claim, and I'm a former care and support worker.
Kia ora tātou, I'm Glenda Alexander from New Zealand Nurses Organisation, Senior Pay Equity Lead.
Kia ora tātou, I'm Nanette Cormack from the PSA. I'm the Pay Equity Advisor.
Kia ora tātou. First point I would like to make is that for care and support workers, this matter is urgent. This is about equity, but it's also about material hardship. It's about children not being able to play sport because care and support workers can't afford shoes. It's about having to choose between rent and power. It's about having bald tyres that you can't afford to replace. And so it is urgent. And it is not just about what is right, but it is about what is required to have a decent life. I also want to make the point that the Supreme Court, and Muriel will talk more about this in a minute, the Supreme Court, which is a body that exists to be impartial, ruled that care and support work is undervalued because it's female dominated, and that work has value, that it's highly skilled, it's extremely responsible, it's difficult, and that what it does is it gives vulnerable people in our community dignity, and that has been undervalued for way too long. And my final point before I hand over to Muriel that I'd like to make is that this is a collective issue, that you cannot fix pay equity individually, that it needs to be collective, it needs to be sector-wide, and it needs to have independent trade unions representing the voices of the workers who have been undervalued for too long. Kia ora.
Kia ora anō, ka nui te mihi ki a koutou ki te whakarongo mai, tēnā koutou. So the original reason for the Service and Food Workers Union, now E2, who took the pay equity case on behalf of Christine Bartlett, was after more than 30 years of frustration about the low wages of care and support workers. And these issues were not being resolved at the bargaining table or during collective bargaining. And Christine won her case against her employer, Terra Nova, despite Terra Nova having initially tried to dismiss the case as frivolous and vexatious. Christine won the support of thousands of care and support workers. She would say she didn't do that on her own. It took all of us. And as you know, Christine was humble, and she went on to become New Zealander of the Year. I was in Parliament with Christine each time to see the introduction and passing of the bill, later to become the Support Workers Pay Equity Settlements Act in 2017, and I acknowledge some of you were there at the time. This bill, which put into law a settlement negotiated by E2, PSA and NZNO and the government, was passed unanimously by all political parties. There was huge cheers in the House and the public gallery. The outcome was that 65,000 predominantly low-paid women workers had between 25 to 50% wage increases, and a new qualification system that recognised the skills these workers used in their mahi. The phased-in period for this expired in 2022. The government extended the legislation in 2022 for another 18 months with a 3% increase to the wage rates. But with the expiry of the Act in December 2023, the minimum rates and qualifications expired too. Since July 2022, the unions have been trying hard to renew the settlement, but without success. Sadly, these workers' hopes have now been extinguished by this current government's decision, and the lives of these predominantly undervalued and underpaid working women have all been shattered. Finally, I'd like to acknowledge the gender pay gap for Māori and Pacific women is much worse than those for Pākehā working women because of the allocation of the workforce, such as care and support work. Nō reira, me aro ki te hā o hene ahu one, pay heed to the mana and dignity of all women. Nō reira, tēnā tātou. And I'm going to hand over to Melissa from PSA. Oh, sorry.
We've changed place.
Kia ora.
Kia ora. My part of the presentation, we heard that you were taking the submission as read, but we particularly wanted to draw attention to the timeline. As Muriel just said, as soon as it was possible for us to raise a claim for this group of workers, we did so on the 1st of July 2022, which is just 3 years just past when you think about it that way. You will see by our timeline that every opportunity was used in order to progress this claim. We believe we did that jointly with the employers, the 15 parties that we work with, and listening to our sisters from the education sector. A lot of what they said to you we experienced as well in terms of the hours that were put into talking, to working through all of the interviews, all of that stuff that we did. And it was robust, and it was very accurate. We made pains to make sure that all the way through reminding ourselves that we didn't want to get to the end of a process and be challenged by anything that we hadn't paid due attention to. So you can see that our work with our members, all the interviews, all the conversations we had right through to when we were subject to the milestone reports, they were key when we had to work through those as well to move on to the next stage. All of that was done with what we believe incredibly due diligence to make sure that things were right. And, you know, we were at the stage that the amendments came through were just with the employment authority waiting to have a determination heard. It's really frustrating, and my colleague Melissa will talk more about the impact and the recommendations that occurred as part of that process, but it was, as far as we're concerned, every step in that journey has been documented, and it involved the hopes and dreams of a lot of people who were covered by the claim.
Thanks, Glenda. Just to add to Glenda's point, we were told the whole way through our pay equity claim that it was done in a way that was gold standard. We were told that by Te Kauamataho, we were told that by various other pay equity experts, that the work that we'd done was gold standard. So I might just talk through some of the impacts of the changes on this particular claim. And a big part of that is that one of the big wins of the 2017 settlement was that mental health and addiction support workers were added a year later. And despite the view that this was a pay equity settlement, it was never described that way. It was always a significant step towards pay equity, and having mental health and addictions added later meant that they weren't included until 2018. So what that means is that the one of that was 65,000 care and support workers being one profession. And if we can't raise a claim until 2027 for care and support workers and 2028 for mental health and addictions, it splits the care and support worker profession. That's even if we could raise a claim. So our view is that it is very difficult to raise a claim under these changes, particularly for this workforce. The merit process is problematic, and it will be problematic for this claim. It's not even clear how that will work in practice. The other issue is that the hierarchy of comparators, when you look at the care and support sector and the work that care and support workers do, and it being highly feminised, it's very unlikely that when you look within the employer there is a comparator. You look outside and we can't utilise a settled comparator. Like some of the comparators we did use in this process, we can't use healthcare assistants or mental health assistants. And there's unlikely to be any other comparator, so the claim will stop anywho. Further to that, the other issues with the changes is that there are over 1,000 employers in the care and support sector. We had 3 care and support pay equity claims with over a couple of hundred employers. The sector's actually over 1,000 employers, and the employers can opt out at any point in time for any reason. And if there were comparators, we don't necessarily have to agree them. And that is hugely problematic, especially because of funding. The last piece I'll just talk to is we've heard very clearly through the document dumps over the last little week, but also OAAs that have been done for the last wee while, that the contingency for pay equity for care and support workers, but also the funded sector, is gone. And the sector is 100% government funded, largely, and the employers are going to need some injection of government funding in order to pay decent wages to workers. They're largely on the minimum wage now, and that's really disappointing because of the complex and difficult work care and support workers provide in our communities every day. It's heartbreaking, actually. And when you talk to our members and the impacts of these changes, they are absolutely gutted, heartbroken, and lost because the employers need government funding to pay decent wages, and that hope of that is all gone. So our recommendations are that there needs to be, the People Select Committee recommends that there is a care and support worker settlement, and that has to be fully funded, and that there needs to be a multi-year funding model to not get ourselves in the same situation as we did in 2017, where all of that hard work has been eroded by the minimum wage going up, and care and support workers have absolutely lost their pay equity, which was a huge win in 2017. So I guess our plea to you is to make some recommendations for the care and support work sector that does require funding, that ensures workers get pay equity, that there's a workforce strategy in place that has progression and training to keep investing in this workforce, because they are needed in the future. They are needed now. We have an ageing population, and we don't have sufficient workers in the sector to deliver that work as it is. The sector is in crisis. Our members are in crisis. Day-to-day needs for our members is getting harder and harder, and there needs to be investment in this workforce now.
As promised, Lynn, you can lead us off, and then I'll go to Leanne.
Thank you very much, and congratulations on your case and for all the work that you've done for workers in this area. The question I'm going to ask is not one that I've asked before, and it's to do with the rhetoric that's coming from the government at the moment around whether it's about nursing ratios or pay equity claims, and there's this you terrible bunch of militant unionists. The unions are driving this as if your members, all the time they've put in and the energy, really don't play much part. And to me it adds insult to injury probably to your members, but I just wonder if you could make a comment on
Now, Christine Bartlett wouldn't have had the courage to do this on her own, and she would say it was because she was a member of the union that gave her that courage too. So,
I think our members think that these changes are a deliberate attack on care and support workers and the care and support worker claim. And if you look through the OIAs, it is very clear that they wanted to manage the risk of this process. The day before this, the announcement of the pay equity changes came out, we were actually filing our evidence in the Employment Relations Authority before we headed to fixing for the pay equity rates for the first care and support worker claim. And that was heartbreaking, but what's now been revealed is this was deliberate and secretive, and this government deliberately wanted to stop care and support workers getting pay equity, and that's evident if you look through our timeline as well, with the interference of funders in our process, which was inappropriate because they weren't party to our claim, and that continued the whole way through the pay equity process. So I think our members think that this is deliberate and an attack on care and support workers.
Leanne?
We had an earlier presentation from Aged Care Association, and it seemed to me that they were saying that there was almost an implication that the government was deliberately delaying, or Te Whatu Ora was deliberately delaying things so that they wouldn't get to the point where it would be referred for a settlement, which actually was the original impetus for the care and support workers settlement, because I think people forget that the reason the government introduced legislation was to ensure that it wasn't the employment court that set the principles for the establishment of a pay equity claim. And I think that's part of the problem is people's knowledge about what this is all about. But it seemed to me when I read the Treasury papers, even as redacted, I wondered if it was a deliberate delaying tactic. And so I'd really like you to talk about that. And then when the government's not the employer, is it bad faith by proxy rather than just bad faith?
Yeah, so one of the ironies in this whole thing is that throughout the process, when we had been working with the employer parties to the actual claim, that there was open agreement as to the degree of undervaluation. Like, I mean, we still had some bits around the fringes to sort of sort out, but essentially it was clear that this work performed by majority, female workforce was undervalued. And I think the outcome, just like many other groups of women and their work, was grossly underestimated how much that undervaluation actually was. So I think the real facts of the matter is, as soon as it was realised that this is going to cost this much, it was just, everything else was designed to forestall that and to make sure it didn't happen, frankly.
I think it also started with the review. So our delays, if you look through our timeline, we worked at pace, faster than most claims, and the review was it was inconclusive in all of the findings, but the biggest issue with the review was that it did not have any way forward or suggested way forward for care and support workers to get pay equity, and it wasn't conclusive. And we think that there's every reason to believe that that was done by design to not deliver pay equity for care and support workers.
Ka pai? Thank you very much for your submission. E mihi ana kia koutou katoa. We'll call on our next submitter, Zoe Eckles. No mai hara mai. Standing up is actually quite a good idea. Yeah. Tēnā korua, no mai hara mai. Thank you for your patience and being the last of our submitters. We want to assure you that you will have the time to be able to present as you wish. Please take your submission as read and there will be questions.
Thank you so much. You have to excuse me, I'm quite nervous. I don't often do things like this. Kia ora koutou, my name is Zoe Eckles and I work as a customer service librarian and PSA delegate for Wellington City Council. I was directly affected by the decision to drop all pay equity claims, and I am here today to voice my anger and my concern for all of those who have been affected by this decision. Before I begin, I would like to clarify that I am speaking on my own behalf and not on behalf of my employer, Wellington City Council. So first, I would like to outline the nature of my job with reference to the many challenges to illustrate the fact that librarians have been severely and chronically underpaid. I have been working in libraries for just over 2 years. Previous to this, I worked at the National Archives of New Zealand, helping to digitise documents for the Royal Commission of Inquiry into Abuse in State Care. Moving from archives to libraries, I took a significant decrease in my pay. I envisioned library work to be just as rewarding but a little less stressful than working for the Royal Commission, which was kind of harrowing at times. And after 2 years of working in libraries, I can say that it is very rewarding work. However, it is not less stressful than working for the Royal Commission. Librarians are an educated bunch. Many of us have tertiary degrees that rival those of people in higher paid sectors. Our work involves an understanding of complex systems, and contrary to public understanding, it does not begin and end with books. Over the past 2 years, I have seen the strain that has been put on libraries as a public service. My daily work can involve a high degree of aggression and violence. On any given day, I may have to navigate aggression and violence and behavior including things like yelling, threats, stalking, paranoid behaviors, spitting, throwing of objects, and even actual punches. Fortunately, I have not been one of the people on the receiving end of the punch, but several of my colleagues have. I have witnessed patrons hitting themselves repeatedly. I have been there for human waste cleanups, and I have had to single-handedly issue a ban to a violent patron when nobody else was available to do so. Moreover, our work requires many skills, including a high degree of care, problem-solving, and technical proficiency. For instance, I have been the eyes for patrons who cannot see a computer screen. I have to solve all manner of computer issues, staying abreast of systems that are continuously breaking down. I manage large groups of children and teens, staying up with the requisite training to do so. I plan events focused on educational topics or cultural holidays, often using my own time and resources to make these workable and fun. I also work as a PSA delegate, caring for my colleagues. It has become increasingly common that I have to work outside my rostered hours to make all these things happen. As you can see, librarians are valuable assets to our communities, and they work incredibly hard. In my second point, I would like to speak to the inherent issues in the newly proposed pay equity system. Library work, especially in the public sector, has historically been thought of as a woman's role, and that thus it is affected by the gender pay gap, which affects many of the people in this claim. They're considered to be women's work. In our collective claim, library staff sought to rectify this historic disparity and make our remuneration equal to our responsibilities. However, under the newly proposed pay equity system, which the government admits will save them billions of dollars, the goalposts have shifted. The system is being rewritten to compare a claimant's role to roles in the same organization, the same sector, or the same industry, something that is inherently void of any sense when it comes to pay equity. For example, if one were to compare library staff with other library staff, then there is no apparent pay gap. In fact, at Wellington City Council libraries, there is currently a slight negative pay gap in favor of female staff. Why? Because the majority of library staff are female, and the majority of people in higher paid positions are female Kaimahi. If pay equity is understood to be equal pay for work of equal value, then, as evidenced by the librarian example, this newly proposed method would result in a limited set of statistics that reveal nothing about the historic nature of a gender pay gap in any given role. And last, I would like to share the impact that the cancellation of claims has had on me personally. When I woke up and I saw the news on the morning that it was announced, I felt really sick. I did not realize until that moment how much I had been relying on a pay equity claim to keep me going with the work that I do. Sorry. Even though it felt like a distant shot in the dark, that claim had given me hope that I would someday have better pay. And I have been struggling more and more to make ends meet, as I know many of us have, despite budgeting strictly as I have always done. And saving, which I used to pride myself on, has become impossible. At the beginning of this winter, I struggled to pull together enough money to buy a new heater when my old heater broke. And to put this into perspective, I struggled to save $250. It is not right that I am working as hard as I do and getting paid just enough to survive and no more. And I know that I am not alone in these struggles. There's so many people who have been affected by the cancellation of these claims. Taking away our pay equity claims means taking away any chance of stability for the hard-working women whose jobs are undervalued. It is like kicking the already wobbly bucket out from under our feet. And finally, I think it is utterly abhorrent that the money that would have been used to provide stability for women in underpaid roles is now being used for the benefit of people in positions of relative stability, including landlords, business owners, and large companies. This is inequality in action. Thank you.
an equally powerful submission, and thank you for bringing your personal experience into play in terms of the examples. There are so many that would feel an affinity with what you have shared with us today. I'll pass the first question over to Dame Marilyn.
Kia ora, Zoe, and thank you very much for writing your submission and appearing. I asked for you to be on this day. Since I was 5 years old, I've loved librarians. And for most of my life, I could not have survived in Parliament without the Parliamentary Library, and I certainly could not have survived as an academic without the librarians, who always know more about IT than I do. One of the things I want to really thank you for is describing the extraordinary diversity of activities that are expected of you. And I think that those descriptions are going to be very, very important for us, especially thinking about the comparator argument. Can you just advise us about the amount of education that you went through to become a librarian, please?
Gosh, well, when I was studying a long time ago, I studied history and archaeology, so I had no idea what I was going to become. But I'm very fortunate. I'm happy that I became a librarian. I think it fits with who I am, and it fits with my education. A lot of my colleagues have specific library education, so a degree or even master's degree in library sciences. I personally do not, but so many of us have tertiary qualifications that go beyond just a simple degree. And the education on the roll, it's quite a lot too. It took me about a year to learn all the processes, just all the processes that require admin on the computers, things like that, the ins and outs of council services that we provide, all of that. Not to say anything about the children's programs and holiday events, and there's so much. So it's an ongoing education, really.
And a quick supplementary off in another direction. How were conversations with local government New Zealand proceeding in terms of the pay equity claim?
Well, I wasn't actually personally a part of these, but I've heard a lot from various people. So if you would like to speak.
Kia ora. I was a co-advocate for the local government claim, which covered 6 of the councils in the country, and the work on that claim had taken quite a long time, but we had worked on a consensus basis, and we had reached the point of bargaining when sadly we had to file in the Employment Relations Authority for fixing, because although we had agreed the value, the degree of undervaluation in terms of the size of the work, we couldn't reach agreement on how that actually translated into rates of pay, from our perspective, particularly compared to the comparators that we were using. But that claim was almost finished.
And do you recall the percentage range of increase you were talking about?
What I would say is that the salary that we said was pay equity was the average of the comparators that we used. The proposal by the employers was to pay the lowest pay of the comparators that we used.
And I did hear that we scored higher than most of the comparators on the stress scale, so that's saying something.
Okay, I'm not surprised. Yeah. I once had a woman come to me to do a PhD, and she wanted to write about what librarians really did, and it was a wonderful proposal, and I really wanted to supervise it, but of course she got too busy.
That doesn't surprise me. In my personal life, I listen to a podcast. It's called Surviving the Stacks. It's wonderful, and it's 2 experts in the field talk about all kinds of problems that we face, including unhoused people in our buildings, like trauma, violence and aggression, burnout. There's so much, and people don't realise just how difficult the job really is.
Wellington City Council has supported one of their library staff to maintain a social work qualification in recognition of all the social work that they are doing in the libraries, which are bearing the brunt of the closure of our mental health day ward systems, giving people with significant mental health issues a safe place to go.
Yes, and on that note, I would like to say there was recently a decision in Wellington City to close down a certain service that was helping unhoused people. Overnight, we saw an increase in the amount of people sleeping outside our library and coming in the door. Yeah.
Thank you very much for your submission and for, again, texturing the context of your workplace, but also the humane side of your experience. Thank you very much. Kia ora. Kia ora. And on that note, on behalf of the Select Committee, I will call our first People's Select Committee on Pay Equity meeting to a close and give back our gratitude to you as submitters who have spent time and effort to be here today, to send in submissions, to be able to provide your local context, to be able to give us information, to be able to draw on as we continue our considerations going forward. E mihi ana ki a koutou katoa, I raro I te manaakitanga o tēnei huihuinga tangata, I roto I te whakaro kotahi. E hara I te mea, no nai nei te aroha, no ngā tupuna I tuku iho, I tuku iho. It is no small thing that love has been gifted from our ancestors and our forebears so that we can remember the eternal gift that unites us. It is aroha. Nō reira, mai koe hei whakakapi I roto I tētahi paku. Karakia, I'll just end with the karakia. Unuhia, unuhia. Unuhia kia wātea te tinana, te hinengaro, te wairua, koiara e rongo e whakairi ake ki runga, tūturu whakawhiti maua kia tina, tina. Haumi e, hui e, tai e. It is released, the things of the mind, the body and the spirit, so that we can leave here united in a common sense of purpose. Be released. Tēnā koutou. Kia ora mai tata katoa. Kia ora. Thank you very much.